So, hello everybody, I'm Jurgis Bartkus, a PhD student from Vilnius University Faculty of Law, and one of the organizers of this conference. And without further ado, as you can see from the program, the opening words, then the opening of the conference will be delivered by our beloved Dean of the Vilnius University Faculty of Law, Professor Dr. Thomas Davulis. So please, Dean, the floor is yours.
Dear colleagues, I would wanted to always to say students, but you are not students anymore. So real researchers, real people engaged in academic and scientific work. That's why the word student is not suitable here. Nevertheless, I'm very happy to be here and to welcome you personally. After, as we Felix have talked, after 3 years of the difficult time of being closed and in an pandemic situation, not being able to meet, we are meeting again, and it happens at Vilnius University at the law faculty, and this is also something new for us to organize the PhD conferences at these new premises. We are very happy to be able to accommodate you here at our home, and it will also hope create a atmosphere of and environment of very nice, very close exchange between you, among you, about very interesting topics. The topics that will shape your life, that will shape the life of our countries, and especially in those times when we, after pandemic, are facing totally new challenges, unexpected challenges. These meetings are making us stronger, are making us wiser, and making us more adaptive, I hope. Before I say a few words, I would like to also address the events in Ukraine and invite you to honor those victims who are already lost their lives in this painful, dramatic events. Thank you. Well, probably you know, maybe it's not, we at Vilnius University Faculty of Law were also among the first to offer the help and assistance to the Ukrainian students and professors. And we have more than 50 students already enrolled in our programs and of law. They are studying very interesting in hybrid way. They're studying international and European law subjects offered by our professors. And they are also studying Ukrainian subjects offered by Ukrainian professors. We employing them currently. And of course, there is a lot of online teaching still. But I think this is a very important step forward to help them to overcome those temporary difficulties in meeting, in teaching, and in sharing the experiences. So we serve to some extent as a hub to welcome all Ukrainian students in law and providing the possibilities to continue their education. What will happen next, we don't know. Probably some of them will be leaving Lithuania for Western European country. Somebody will come back, but at least we are offered not only our homes, our hearts, but also the university and everything what we do, we share with them. Coming back to our PhD conference, we call this PhD conference, and we call the network in which we are working PhD network, as a symbol of long-lasting our friendship with with Poland, with Polish universities, especially Łódź University, with French universities, Nanterre University, and German universities. And Johann Wolfgang Goethe University in Frankfurt you are our main partners, you are our main collaborators in I would say, in our work in terms of international cooperation, and we are very happy that you are so close, that we feel you every month, every day, and we organize things together. So I think this is very crucial in those difficult times, to have reliable friends, reliable colleagues, and to work together hand in hand by offering our services to those who are in need, and especially for the students, for our PhD students, and currently for young researchers. So this conference today is also the event which is traditionally organized at Vilnius University, but nevertheless we have also the activities under umbrella of the network, and we are meeting also on regular basis in Łódź, in Paris, and in Frankfurt. And I'm looking forward to those meetings again with our students, with our professors. Today we start important conference, important because this is the first conference after a very long time, but also the conference fully organized by the PhD students themselves. This is very nice tradition that PhD students are involved so strongly in the process and understand the need and the possibilities which are offered by the direct participation in organization, in management, in presentations of their researchers. I would like to thank all of those students, Lithuanian and Vilnius University students who were there in organizing this conference, especially Jurgis Bartkus. He is the heart of the pumping heart of this particular conference, and I hope that you have enjoyed the preparation and you will enjoy participation. So this is something what is unique in academic exchange, that being able to organize things that please you, that please your colleagues, and that show hospitality. This is something in our blood. That's why I'm very proud of you, and I hope everything will go smoothly, and our friends and colleagues will be not able to present their excellency in their research, but they also will fall in love with the Vilnius, with the Lithuania, and will find a lot of friends and contacts for further cooperation. So I'm sorry for speaking so long, but indeed I felt I would like to express how much I missed you all, and I'm looking forward for a very fruitful conference, and thanks again for everyone who was able to come, and we will be continuing working. Thank you.
Thank you very much, Dean, for these kind words. And without further ado, I would like to introduce the first and probably the most important keynote lecture of this conference. International Justice for Ukraine, Turning Impossible to Possible, will be delivered by Vice Minister of Ministry of Justice of the Republic of Lithuania, Gabija Grigaitė-Daugirdę. She's also obtained her PhD from Vilnius University as well. She's a lecturer here at Vilnius University, and what is, I think, most important in this regard is that she, together with her colleagues from Ministry of Justice, working constantly to bringing justice to Ukraine, to prosecute war crimes that are happening due to unlawful Russia's aggression in Ukraine. So please, Vice Minister, the floor is yours. I will just turn on your slides.
So, good morning, and Thank you for the possibility to be here with you today. And, drinking coffee, I got the question, how I am here and what the topic I had for my PhD. And I think I got myself back, and I remember I was writing on humanitarian intervention, and when I was defending my thesis, I got a question why I have chosen the topic that in Lithuania nobody is interested about, and how it will sort of be situated in my professional path, and what I'm going to do with it afterwards. Because there was also a remark that we only have one helicopter and we use it only for saving people in the sea, and we are not thinking about saving others abroad, And at that time, I did not have the answer, but today I have, because you never know what can happen in your life. You never know where can you find yourself, in what situation, and you can always take the best of everything you have studied before that, because one day you will definitely be there where you have to be and where you can make a lot. So I always think that keynote speech is about inspiration, not about teaching. So I hope that today I will manage to meet this challenge. So in my sort of keynote speech, I would like maybe to touch on the issues, not only to speak on the academic point of view, but actually to give you the idea how, as being international public lawyer, to make sure that international law is being respected and its values taken to the fullest. So today, I think the key issue for the people working with international public law is how to ensure justice, first of all, for Ukrainians, but later on, how to make sure that solutions that international law offers, they don't fail. Because we definitely have solutions, starting from sanctions, state responsibility, individual criminal responsibility, using universal jurisdiction. So overall understanding that we definitely have those means, how in our daily work to make sure that they succeed. So during all these 3 months that we as Ministry of Justice are working in this field of bringing justice to Ukrainian people, the guiding idea that we have with the minister I'm working with is that it always seems impossible until it's done. Because we have never done it before. Everything we do now, we do it for the first time. We have to use, the texts that used to be written by academics. We have to find somebody that would explain us how it works in practice. We also have to find people that are capable in thinking not only in the perspective, that national sort of peculiarities could be there, but also to show that, we definitely can do it, and we definitely know how to do it. So how to path this way from impossible to making possible. So I will try to give you the rules that I created for myself. And the first one is terminology, that definitions of international public law, they have to be used and not abused. And if you think that this is an easy thing to do, you have to think it twice, because international law is very closely connected with international politics, and understanding that if you take use of force, you have, use of force, you have armed conflict, you have armed hostilities, you can have as the gravest form of the use of form of aggression, but suddenly you start having, and I'm not talking about only propaganda that Russians are using, I am also talking about communication that European Union member states are using, and suddenly you find in the common press releases, communique being, sort of adopted by different politicians, you start having like operation, armed hostilities, crisis in Ukraine. And you understand that this is the explanatory work that you have to do, because for Lithuanians, you do not have to explain what it means, to live under Soviet rule. We remember it perfectly because, the second occupation, it lasted for almost 50 years. So for us, we immediately have understanding we have to have, but we have to do enormous effort to explain it for the Europeans that we meet, because they do not have that idea automatically that you have to call everything by the name that it has to be called. And, because for politicians to explain, that international humanitarian law, it does not care about the reasons that you are in the conflict, but politicians and jus ad bellum, it cares, because after the UN Charter, we have very clear system and very clear exceptions, that is self-defense and UN Security Council authorizations, and that are the only reasons that can be there. So you have to say that, if you say it armed conflict, you do not refer to the reasons or no reasons as we have now in the context of aggression against Ukraine. So you have to call it, aggression. You have to speak about unjustified war, but not crisis as a, or operation. And this is really hard, and especially you understand when you work with people from communication or politics. For them, they sometimes like to take advantage of not putting, that much strong, wording into the text. But I think that, and I put it in my slide, that unity of states starts from the usage of right terminology. Because if we want to be supportive, if we want to stand with Ukraine, we have to say it the way it is and not to pretend, that if we call it crisis, Russia will behave differently, because it will never will. So, and especially, and today when I was driving here to university, there was discussion on the radio about how much Russia invests in propaganda. So understanding this, if we are not that precise with the terminology we use and not strong with the terminology, that means we already are losers. The second rule that we have is justice delayed, justice denied. And even though understanding that searches for justice, especially when we talk about international public law, it will take time, and it will definitely not be fast. But understanding this, the other morning when aggression started, we realized that, if we do not act, now, if we do not show that we are not okay, with what is happening, that means you can give the idea that you are still maybe thinking about or looking for some reasons to justify. So the minister, the next morning, that was Friday, she said, we have to do something and we have to do it on Monday. I don't know, she said, write to criminal court, to court of justice, whatever, just do something. And we did. And how we did it, because I think we were right people at the right time acting together, because, in the Ministry of Justice, we have 140 people. And if you ask me how many people work with international public law, it's me and my colleagues. So we are two. So if you understand that you have to do something on Monday, so I'm not talking about it's weekend, but still, being two, it was at that time for me, it looked impossible. But if you have that motivated politician on your side, if you understand that you share this common interest in the way, that you understand Ukrainians that are suffering immediately. And what is also important, and I think to notice in this conference, is that you definitely have to remember that academic expertise is there. And if we talk about ICC, or now we are working on the case to the International Court of Justice, we do use academic expertise, because academics, we do know a lot. They do know how to theoretical maybe obstacles that could be there. But definitely, if you have ability, sort of to find them, to share the common goal and to show them that they can be there for you to help. They will always be there. At least from the experience I have from these 3 months, so definitely yes. And on Monday we had the results. We have been the first one to refer situation in Ukraine to International Criminal Court. And United Kingdom, by doing it on Tuesday, they were shocked. How is it possible, that Lithuania, who has never done that, did it, during 2 days? So I think that this is the beauty, of international public law also, that if you sort of, because now we have, I don't know, more than 40 countries joining the reference that Lithuania did, because if you show that common interest, and it can really make a prompt change, because afterwards, in April, we met chief prosecutor from the International Criminal Court, and he said, I was astonished because, with this common interest that was there, we immediately got finances, because Lithuania first, we transferred 100,000 euros for the court, but the others followed. Okay, the prosecutor, of course, he raised the issues, what about impartiality, independence, and, but unity is important for International Criminal Court also, because international mechanisms, I think they will never fail if states do not allow them to fail, because, like International Criminal Court was criticized that, it is sort of partial, concentrating more on Africa, and not talking about, problems that European region had. And now we understand we have a chance to show that they are effective also, that they are able, to bring justice quite fast. And, the prosecutor also said that he also doesn't think, that justice is the real justice, that people do not remember when it started. So he understands that this is a test case for him also. So I hope, that he just does maximum he can, to make sure that it will not last for 10, 20 years. And at least he is motivated to do that. And afterwards, there were many important, I would say, evolutions, because we had a joint investigation team established by Lithuania, Poland, and Ukraine. And ICC also joined this international joint investigation group, because it is important, that we sort of have a common storage of evidence, that we can have linkage proved, between the crimes that are committed together with the victims that we have in Poland, Lithuania, and in other countries. So to be able, to have the shared resources, to share know-how in the evidence evaluation, in the sharing experience, that Lithuania, for example, has in the prosecution for the January 13 events. So all in all, it makes, this common effort. I think that it will definitely bring justice to Ukraine, and I hope that it will not take as much as in other cases that ICC deals with. The third rule that I have is that you always have to look for the like-minded states. And, the common interest is always there, but sometimes you have to find it. It is easy in the context of aggression against Ukraine, because, it depends on the topic. About ICC, for example, it's quite easy. I will later touch upon the issue on the special tribunal, so you will understand that it is much harder in that case. But anyway, the rule is that, you understand that what you can't do alone, maybe, you can do together. And it is the only difficulty is that that you have to know how to approach different states. And I will give you the example that I met ambassador from Netherlands, and she is a very nice lady, and we started talking about how Netherlands see themselves in European Union, and she said to me, Gabia, we see ourselves not as being the biggest from the smallest, but we see ourselves as smallest from the biggest. And this is, you know, this is the idea you have to have, because you have to understand how each country sees itself in the bigger picture of the politics that she is in, because the arguments that we are using, we are, you know, saying that we are small, but we understand Ukraine, and we sort of always invite the Baltic states together, because at least we think that showing this Baltic support is important that we act together. So in sort of these silent, you know, talks and silent politics, as we're using that, you know, sort of you have to find the way how to approach different countries. It is very important that if you want to make a change, you have to look for the like-minded states. And, you know, for the same reason, Ukraine is now inviting other countries to join its ICG efforts in the case concerning false allegations on genocide, because we understand that this is an important question. This is erga omnes obligation. This is interpretation of Genocide Convention. If we stand alone, it is one thing, but if we stand, you know, together with 20 or 30 states, that definitely makes a difference. It definitely sends the message to the court before they, you know, handle the issue of admissibility. And that is why we have to talk about these like-minded states, and especially if we think about the future, because we have to understand that ICC will definitely pass judgments. We also will have judgments from national jurisdictions on the basis of universal jurisdiction, and we will come to the issue of enforcement. And it's not about only getting sentenced people to serve the judgment, but sort of to give the idea that justice can be enforced also. And you know, we had the story of our arrest warrant being refused by Greece. You know, saying that, you know, it was in absentia, and, you know, it was continuous appeal, and we just rejected it. So if you understand that you will have more and more such judgments, and if you have a judgment in absentia, the right of appeal is never ending. So if you treat it as a continuing process, and this is the one obstacle that you can refuse to implement arrest warrants, so that means justice for international crimes can never be enforced. So that means, you know, using this situation, we raise this question now, because when the time comes to say, you know, that, okay, we have judgments and what we do about them. So we already start now looking for this like-minded state, because we want it to succeed and not to fail when the time comes to enforce it. And the last rule that I have, I think this is the most challenging, because lawyers, you know, at least from my experience working more in the public administration area, that sometimes lawyers that we have in ministries, I don't know, in parliament, whatever they could be, they are sort of, they consider themselves having a mission to defend the existing rules. And sometimes they are very creative and very enthusiastic about, you know, that this is the rule that has to be, you know, preserved and sort of give it safe, you know, haven, because it's just, you know, that it is already there. And but I always admire international public law, because it does not have one, how do you call it, authority that enacts the law. It is all about the states. Of course, jus cogens is untouchable, but it is always about the practice of states and about will of states. So if you find like-minded states who think that the law that is on the hands does not afford justice, it's for these like-minded states to change the law or create new rules, because if we understand that the system that was created after the Second World War does not operate to the aim of justice, it is not just anymore, that means we have to think about other systems that could work, or to create new rules. So that is why, if we understand that we speak about responsibility for the crimes against humanity, war crimes, but for the crime of aggression, we do not have a mechanism, because International Criminal Court, theoretically, it can be the best mechanism, but not for the Russia that we have today. So the only feasible solution today is to have a special tribunal only for the crime of aggression. And, we understanding that international public law has many solutions, like we can have multilateral agreement, with the international organization. It can even be European Union, because we have Kosovo example. It can also be a multilateral treaty, between separate states. Of course, it can be United Nations, but we understand that we have Russia there. So even though we understand that the solution is there, we definitely confront international politics, because international law is very closely connected with international politics. And the argument, when we do these silent talks with looking now for like-minded states to do that, and what argument we hear quite often, like, how can you imagine that you have special tribunal for the crime of aggression against one of the permanent members of the UN Security Council? Because for countries, it is something, that it's not about making it possible. It's even hard to imagine. But what the other question I ask backwards, I say, but can you imagine that you have permanent member of Security Council in this crystal clear act of aggression against European states? Because we have no reasons at all, because people start comparing, yes, but why don't we have tribunal for the United Kingdom, for Iraq, or France, Libya? But I say, okay, but wait, because reasons for the use of force are different. But here we have no reasons. And when you think about the concept of aggression, the first idea that you have is what? Is the war that is there and aggression that Russia started against Ukraine. So I hope that, we had very important conference in Vilnius that was in the beginning of May, talking about what are legal possibilities to prosecute, Lukashenko and Putin for the aggression against Ukraine. And, we had many professors with us, and the answer was clear that the only way forward is to create this special tribunal. And today we already have resolutions of European Council. We have a resolution that was just recent this week by the NATO Parliamentary Assembly. And we are also thinking of bringing this question on board in the Council of Ministers of Justice that we have next week. So we are definitely moving forward. So these are my rules. And to conclude, for you as being, almost knowing everything about international public law, but I'm sure that you understand that you can never know everything about international public law, because it is as broad as, the world. But I have 3 rules for you, if you see your professional path, in this amazing area of law. So all lawyers always can, and in all ways. That means, especially if you work with politicians, you understand that, I always say to my minister, so tell me what you want. Because, it's not, you have to want, and I sort of give you the arguments, how you do it, or how you argument on one or the other way. International law is about working in a team of countries, in a team, with academics, for Lithuania at least, because, we do not have that much practice or practitioners that could lead us immediately straightforward to the result that we want. And I always say change to have a chance. So if you stick together with like-minded states and you use the expertise that you already have, and you are brave and motivated, enough to bring a change in law. So and very important to make others believe, that the change is needed. So definitely the others will follow. And turning back to the title that you have for the conference, just never be afraid to ask, because if you're afraid to ask, then you do not work as a lawyer, because lawyers are never afraid to ask. So good luck, thank you, and have a nice conference.
Thank you very much for this, I would have to say, insightful, interesting, but also motivational keynote lecture. And I think it poses the questions to all of us: what can we do as lawyers more to pursue international justice? And without further ado, I would like to start the first session of our conference, questions about law and war, Russia's aggressions against Ukraine. And now ask moderators and participants of the session to join us in up front.
Dear students, dear colleagues, friends, and PhD students, young researchers, you are especially welcome to this conference, which is annual. And may I once more welcome. And you perhaps have noticed that this annual conference bears a very unique title each year. And so this session is also having the title that is none less specific for us, because questions about law and war, Russia's aggression against Ukraine. So these questions, are lying at the bottom of our hearts and also in our minds. And they have been there since the very first days of the aggression of Russia in Ukraine. And so the topic has been a challenge for the unity of international community. And this topic also has been, the exam for the values of each of states. And also, this was a huge humanitarian tragedy for each Ukrainian. And at the same time, it was a huge challenge for international law. Because after being shocked and paralyzed within the first days after the aggression, international community turned to some action. And so it still is active in providing weapons, in creating new mechanisms, in turning impossible to possible, as the Vice Minister presented very clearly. And so, there have been also still many situations when we wondered, where is the right of collective defense, of collective self-defense? Why Ukraine is fighting alone, yes? And why evacuation routes are only declared as human and safe, but in practice, in reality, they are not functioning. Not even to speak about the UN Security Council, because entrusted with the main aim of ensuring international peace and security, now we have Russia. I'm not sure about China, but the country which should be responsible for human rights protection, but it is the main field and the direct source of insecurity in the world and in Europe. And, you know, we have clearly realized that those unusual situations, as we have this one, demands unusual, specific, non-standard response. And this have been demonstrated by states, by international organizations, and also by numerous formats, academics, starting from proposing special tribunals for the crime of aggression, and including such issues as expulsion of the state from international organizations, institutions, like was done in the case of Russia's expulsion from the Council of Europe, and also from the Human Rights Council of the UN. And you know, throughout that history, we have noticed that at least 3 topics have been among those most crucial ones. And the first one was crimes against humanity, because international community more than once faced such crude atrocities as genocide in Rwanda, as Srebrenica tragedy, as we had also tribunal for Sierra Leone. Yes, we had Nazi regime, we had other regimes, including Soviet regime, which unfairly, due to the results of the Second World War, remained unpunished. The Soviet crimes, all deportations, camps, starvation policy as applied, for example, in Ukrainian case. So never again, international community, this aim failed to realize, because we again face what we face in Ukraine. The second one was the outdated and archaic structure of the UN Security Council, because again, due to the veto power, we understand that the main instruments that we should have, so the instruments starting from sanction mechanism to ordering peace accords, to other measures ranging to interventions, military if needed, as the final outcome. So this is impossible. Also, filing Russia to the International Criminal Court, also impossible due to Russia's participation. And the third one was the propaganda, so the information war, and also the Ukraine's turning to international justice, because Ukraine managed within a very short period to collect, to invoke each and every remedy. And starting from the Court of Human Rights, which prescribed the provisional measures, the first one was also the International Court of Justice and Permanent Court of Arbitration, the Law of the Sea Tribunal. So we really should admire what Ukraine has accomplished, not only in the battlefield, but also in the law field, in the legal field, because Ukraine is using the lawfare for seeking protection of its territory, of sovereignty, of humanity. So that is why I'm really very pleased that all these 3 items I found in the presentations of our 3 guests, our 3 colleagues, which I am now going to give the floor to, starting with the first one. And I was informed that we are going to have this presentation in an online form, and I already can see on the screen Lilia Timofeyeva. Lilia, could you say us hello? Do you hear us?
Good afternoon. Yeah.
So,
good afternoon from Ukraine, and I feel pretty happy and proud to be here. First of all, thanks a lot for supporting Ukrainians and Ukraine, because it's really important for us now. We feel this support from Lithuania and from other countries, from everywhere. And it makes our it makes us more stronger for these situations. I do believe that scholars and scientists can save our world and save our planet, because it's our sentient front, and every one of us can do it from our sides. And my presentations would be about challenges in combating crimes against humanity. I would like to start with a statement of Hugo Grotius in his fundamental work on the law of war and peace, where he raised the questions of whether war could be just and what kind of war would be just. On the next pictures, you can see how our cities are changes. And that's why the statements about just war provoke controversial feelings and reactions. In Kharkiv, Kiev, Mykolaiv, Kherson, Mariupol, Odessa, and other cities, civilians, children, women are being killed. The militaries, hostels, ambulances, attacked and bombed. How it can be fair, actually? Nobody could have expected that in the 21st century, there is a place for such horrific crimes against humanity. However, Ukraine faced them. On February 24, Russian Federation started a full-scale invasion of Ukraine. As a result, a huge number of Ukrainians have already been killed. Damages have been caused to the Ukrainian economy, culture, and property as well. It seems to me that war couldn't be just anyway, but it is extremely important to follow the international standards of human rights. And the international community has adopted plenty of documents aimed at protection universal values, in particular the Convention for the Protection of Human Rights and Freedoms of 1950. These fundamental human rights and freedoms are common for all people, and it was adopted to attract attention on crucial things for everyone, every World War II. Not only does this problem concern a single country, not only Ukraine, but all of humanity. After the aggressions against Ukraine, there is a danger to the security of other countries in the world. Agreements and principles of international law mean nothing for Russia. This country manipulates information, facts, and people. It looks like George Orwell in his 1948 wrote about Russia, specifically about the Ministry of Truth, which dealt with lies and manipulation, the Ministry of Love, which dealt with torture, and Ministry of Peace, which dealt with war. On April 13, the International Criminal Court prosecutor visited Bucha as a place of war crimes. But the Russian government continued to insist that all of these couples in Bucha are staging of the United States of America. Let's consider the definition of war crimes in accordance with international documents. Article 8 of the Rome Statutes fixed the meaning of these crimes. Actually, it includes killing civilians and attack to civilians object. All of these crimes are committed in Ukraine. And it is significant that the Rome Statute also includes rape, sexual slavery, enforced prostitution, forced pregnancy, or any other form of sexual violence of comparable gravity as crimes against humanity when it's committed in a widespread or systematic rape. Rape during war has a genocidal context because of connection with discouraging women from reproducing in the future, intending to terrorize their population, destroy communities, and change the ethnic makeup of the next generation. Moreover, it is also used to deliberately infect women with a dangerous disease. This issue of rape is especially relevant in connection with aggression of the Russian Federation against Ukraine. So investigators of Ukraine should be careful with qualification these crimes. It is not just the rape as a crime against sexual freedom, but as a war crime. It might be a bit challenging at first because we haven't such practice, but it is another object and another consequences for the criminals, actually post-criminal consequences. Next significant point is the international mechanism of investigation. Unfortunately, Ukraine has not ratified the Rome Statute yet, but on February 28, the International Criminal Court prosecutor started an investigation into the situation in Ukraine. And it's really important that witnesses can provide evidence of war crimes directly to prosecutor by email. On March 16 was announced the order of the International Court of Justice in the dispute over the international interpretation of the Convention of the Prevention and Punishment of the Crime of Genocide. And first of all, the Russian Federation refused to close the case. An armed attack cannot be conditioned and justified by the accusation of the victim of aggressions in genocides. Last but not the least significant point is a human treatment with captives. The principle of humanism is expressed in the fact that a person who commits a crime, including a war crime actually, and crimes against humanity, is still a human with his rights and freedoms. The state has a right to illegal actions, however, such reactions should not turn into a crime. I'm pretty confident that participants in hostilities in Ukraine have to strictly follow the current norms of international humanitarian law, and what Ukrainians should not to do is commit war crimes against captives. According to social media, Ukrainians show some dissatisfactions with the human treatment of captives, their feeding, medicine, and so on, because of current economic situation. But if Ukraine treated them cruelly, the state would also violate international law, especially Article 3 of the Geneva Convention. It includes actually violence against life and person, including all norms of murder, mutilation, ill treatment, and torture, hostage-taking, abuse of human. To sum up, I'm absolutely convinced that that is nothing to begin from war, because humanity, human rights, everyone human is a value. Any politician ambition is not worth a human life, and Russian invasion of Ukraine, the use of weapons of mass destruction, it is not encroach not only on territory of Ukraine. Moreover, any armed invasion of the territory of another country in the 21st century is an encroachment not only in territorial integrity, it is encroachment on European values. These values have been built for centuries in response to the experience of war, and the best way to deal with crimes against humanity and war crimes as well is the integration and unity of the international community in combating these crimes. Working hand in hand, looking out for each other and supporting one another, we will win. In conclusion, then human rights standards should be complete with people who have committed and been involved in crimes against humanity. The civilized world should respond to and ensure security by civilized method. It is crucial for our European direction and to stay human being. This can have a positive impact on justice in general. Thanks a lot for your intention and your support. Glory for Ukraine, victory for Ukraine, and stay with Ukraine. I am ready to answer of any of your questions. Thanks a lot.
Dear Lilia, we thank you so much for sharing with us the challenges in combating crimes against humanity. And I'm trying to keep to the established schedule. That is why I would like to invite our second guest, and the panelist is Veto Ibrahimov, who is arriving from the Martin Luther University, Halle-Wittenberg, and is going to share with us the paradox of voting, so it's the peril of the vetoing of the perpetual peace. And we are waiting for Veto to appear on the screen here. Meanwhile, I could really share the view that more and more international organizations are reporting the crimes against humanity, war crimes, genocide, and we are responding with a very huge speed to everything what's happening in Ukraine. This is in support to what Lilia has just presented us. And now I say once more, I address once more Veto Ibrahimov, and so the floor is yours. We are waiting to hear your topic, please.
Hello, good morning. I think all hear me very well. Yes. So I just, thank you. So I just signed in. So as far as I understood, should we start presenting our topic, or just because according to the plan, it is planned for the 11:15?
Yes, please. You are welcome to present your topic.
Okay, because on the plan it was 11:15. That's why I'm a little bit surprised and puzzled. Okay, then.
Is it my mistake? No, it's 11. Is it okay? Yeah, organizers show me that it should be okay.
Okay.
Is it fine with you?
Yeah, it's totally fine
Good.
with me. And
then we could proceed. Thank you.
Yeah, and I can share my screen. So I think all see my screen now. So do you see the presentation now, or?
Yes, we can see your slides. Thank you.
Yes. First of all, thank you for giving me a chance to be part of this project today. And I think I must say a couple of words about the importance of the conference. So I just start with this slide where you see this sapere aude, which is calling us there to know. And This comes from ancient Rome period, and it was also the motto of the Enlightenment during 17th, 18th centuries, especially in the essays of Immanuel Kant. And here I put the picture of the symposium where people usually were gathering and discussing certain things. And I think gathering together and discuss certain things is very important, especially asking questions, although there are sometimes no answers. So thank you all organizers and everyone in the back scenes. So first of all, a couple of words about the World War and the UN. About the First World War, everyone was saying that it was a war ended all other wars, all the wars before. But as we observe, the history proved the otherwise, and the Second World War was happened. And another topic is here is the League of Nations, which was failed again which was existed 1920 till 1946 and again failed. And around 40, even some say 50 million people were the victims of this war. So this is this is exactly one of the bloodiest war of the mankind. And therefore it urged mankind to come up with a special peace project. And that peace project would be the United Nations, which will be established in 1945. But before the establishment of the United Nations, the victorious states already decided to have a conference to design the monetary structure of this organization in Bretton Woods Conference in 1944. And there they established it was a financial conference mainly, and they established the International Bank of Reconstruction and Development and also International Monetary Fund. I will not go the details of those, but I just tried to briefly cover the historical background, what happened before the United Nations. And then, so new world order was established with the United Nations in 1945, and again, the Charter of East was adopted. So a couple of words about the Security Council itself and the veto power. When United Nations established, the Security Council was intended to operate as an efficient executive organ of limited membership, functioning continuously. So it was given a huge primary responsibility for the maintenance of the international peace and security. It consists of 15 members, of which 5 is permanent, as you can see the name of these countries, and 10 is temporary, and they are elected by the General Assembly for 2-year terms. And in the in the Charter of the United Kingdom, there is an implicit veto power. Why I use here the word implicit, because we cannot find the exact word veto in the Charter itself, but in the next slide, we will see how it is drafted and added to the Charter. So this is Article 27 of the Charter, which is talking about the veto power, which in these days, most of the international lawyers are talking a lot about this, what is happening regarding with this, the war we have now. And so the first paragraph says each member of the Security Council shall have 1 vote. Decisions of the Security Council on procedural matters shall be made by the affirmative vote of 9 members. And decisions of the Security Council on all other matters shall be made by the vote of 9 members, including concurring votes. Here it is important. So the concurring votes of the permanent members, provided that in decisions under Chapter 6 and under Paragraph 3 of the Article 42, party to a dispute shall be abstained from. So 52, sorry. And as you can see here, I highlighted 2 parts of this Paragraph 2 and Paragraph 3. So first of all, it is important to see the concurring votes of the permanent members. So permanent members should concur in those decisions. So this gives these permanent members the veto power. And second, as we can see in the next slide, I think, yes, it's this one. First of all, I want to talk about why they have this veto power when the League of Nations failed, because in the League of Nations, all members of the League of Nations had veto power and they could block any decision. And some legal scholars say that that was one of the reasons that League of Nations failed, because every state could potentially block any decision against it. And why, again, it is not a surprise. I did a little bit research, the historical background of this veto power, and it came to me that one of the states was Soviet Union mostly wanted to have this veto power in the charter, and the reason for that to protect itself from the Western bias, so say we can say, and so that therefore they said we have to have it in the charter, and as we can see. So I want to back to this slide again. Here I highlighted with the blue color the procedural matters and all other matters. So even till today, it is not clear which matters are procedural matters and which matters are all other matters. And even when the permanent members want to decide on it, this is again decided in the Security Council itself. So any matter could be a procedural matter, or any matter could be within all other matters. It is also problematic, and some also can argue that, we can also argue that the Big Five had this provision in the convention to intervene to the global issue and to do whatever they want to do and to be protected, to use this article as a shelter for their, let's say, wrongdoings or any other doings. So now I come to the paradoxes. As you can see, the name of my abstract is the paradox of voting. Why I use the word paradox, now we will see it. No specific procedure to remove permanent member of the Security Council, but there is a procedure to remove a normal member, let's say. That is Article 6 of the Charter, as you can see. A member of the United Nations which has persistently violated the principles contained in the present Charter may be expelled from the organization by the General Assembly upon the recommendation of the Security Council. Here again, I highlighted the important part of this article. You can see that it is upon the recommendation of the Security Council. So if you want to expel any country from the organization, that should be recommended by the Security Council, and that recommendation again could easily be blocked by the permanent member when the case is about that exact permanent member. So this looks like to me as a paradox, because for example, when we are discussing the X country and Security Council wants to recommend that permanent member should be expelled, that exact security member could easily block this decision, this recommendation decision in the Security Council, and General Assembly will never receive such recommendation. So, and second paradox, how we can amend it. So it's about the amendment, and as you can see, Article 108 is about the amendments. Amendments to the present Charter shall come into force for all member states of the Union when they have adopted by a vote of 2/3 of the members of the General Assembly. And here it is important again, and ratified in accordance with their respective constitutional processes by 2/3 of the members of the United Nations, including all other permanent members of the Security Council. So when we want to amend the Charter, again, all permanent members should ratify it. Without ratification of the permanent members, this amendment will never come into force. Because this is again, so let us say if we want to amend Article 27, which is about the veto power. So let's say we want to amend this article, and when we want to amend the veto, this article, and to prevent the permanent members from their veto power, they would never accept it for sure. So that is another paradox, and we don't have any clear answer to this one. Although there were some reforms were suggested in 2015 by Kofi Annan, but that was not accepted, never implemented. So in the next slide, I want to talk about a little bit about sanctions. Do they work? So as we know, so every day we are talking about sanctions, and every day each European Union and United States and other states are applying sanctions to the aggressor. So do they work? It seems in a short period, they seem like they work, but I would like to ask here again another question. And you can see a little passage from the philosophical sketch of the Immanuel Kant. He says, "No treaty of peace shall be held valid in which there is tacitly reserved matter for a future war." I want to apply this thesis to the sanctions of today. And when we see that these sanctions are temporary, and it is highly likely that these sanctions will be lifted when the war stops, most probably we will see that. But for now, when we can argue that these sanctions is kind of postponement of the future war, although they can work today, they are not guarantees for the prevention of the future war. So that is another question and another problem I see in this matter as well. So of course, it is better have them than nothing. I understand that, but that is also problematic. And I want to conclude again some passages from this philosophical sketch, which is saying that we have to found a federation of the states, and no nation should be excluded from this organization, from this federation. Of course, we remain with unanswered questions, and maybe we need to reinvigorate the existing international order and instruments as well. But we don't know that, we don't know how to do that, how we have to do that. And again, I want to say a final word regarding this situation. And as you can see, Kant says a state is a trunk with its own roots. To incorporate it into another state like a graft is to destroy its existence as a moral person, reducing it to a thing. Such incorporation thus contradict the idea of the original contract. So in our case, original contract was the charter, and the permanent members vested upon powers to protect international peace and security. And now we see that doesn't work. They abuse their powers there, and they are destroying one country as a moral person. And this action is definitely goes against the moral values, all other values of the original contract, original charter of the United Nations. So here I end. I have some sources here, and here I end my presentation, and thank you for your attention.
We thank you also for things to think of while I am turning to the third panelist, our guest from the University of Lodz. And I have him here with me, so it's Miloš Gapsa, yes? And it's up to you, but you may take the floor perfectly. And meanwhile, I'll present your topic, which is about not merely about the provisional measures of the International Court of Justice in the case allegations of genocide, so Ukraine versus Russia, that was initiated by Ukraine within a couple of days. But the ending is, but the media reports inaccurately. So Miloš will explain us. Yes, and you are welcome to present. Thank you.
Yes. Can I see my presentation? Okay. Yes, everything works. Okay. So, good morning, everyone. It's still morning. Yes, I think so. And my name is Miloš Gapsa. I'm a PhD candidate at the University of Łódź in the Department of the European Constitutional Law. And it's my great pleasure of appearing before you with my topic, quite long one. All we need to know about the provisional measures of the International Court of Justice in Ukraine versus Russia, but the media reports inaccurately. Of course, this topic directly relates to the theme of the entire conference. And I know that your first question is why such a topic, quite a long one and maybe not a typical one. And this is due to my PhD, because during my PhD research, I focuses on comparing provisional measures of different international courts. And life provides us with some material for analysis. Unfortunately, now this is this unlawful Russian aggression against Ukraine. But we as lawyers, we always like these legal battles in court. So now we've got these proceedings before the International Court of Justice. And as you can see from this press release on 26 February 2022, so 2 days after this war started, Ukraine filed an application against Russia in the International Court of Justice based on the Convention Against Genocide. And why this convention? Because Russia claimed that this whole special military operation started due to the fact that Ukraine was committing genocide in the Donbas region. We all know this is false, but you know. And Ukraine simply used this convention to bring this whole case to this court. And as this is the topic of my PhD, so provisional measures, because Ukraine also asked the court to grant provisional measures, which were granted on 16th March. So this is topic of my PhD, and I vividly watched it live. And I was all the more surprised to watch and listen how Polish media covered the ICJ decision, and it got most of the elements wrong. And I also checked other media using the languages I know, so English, French, and also Spanish, and unfortunately only Polish media made this mistake. So now I'd like to present you what the ICJ said in its order concerning provisional measures. Secondly, I would like to present you how Polish media distorted it. And last but not least, some suggestions for us as young lawyers ready to conquer the whole world. Okay, but first thing first, and I think this is quite important for us to recall what provisional measures are. And the first and maybe the most important thing is the fact that they can be called interim measures, provisional measures. Different courts may use different names, but we are still talking about the same thing. And here you've got this lovely passage from this very, very important book saying that interim orders are issued at the end of incidental proceedings, often with the aim of safeguarding the object of proceedings or to ensure that the subjective rights in question are duly safeguarded. I think that this definition makes it all clear what these provisional measures are. And it results from the jurisprudence of the International Court of Justice that 3 conditions must be met to order interim measures. This is to say the court must find that it has jurisdiction prima facie, so there is some basis for the International Court to judge, and this whole quotes are from this order. So this is what the International Court said. Then the court must find that the sought provisional measures are plausible. This is to say that they are connected with what the applicant is seeking in the main proceedings. And last but not least, the case must be urgent. So some irreparable prejudice can occur at any moment before the final judgment. And also, I'd like to look briefly on the Ukrainian application itself. And usually states claim that they have right to something or that the other side has violated something. But Ukrainian application is really different. And to sum it up, Ukraine claims that it has right not to be subjected to false claim of a genocide, and it has right not to be subjected to special military operation as the abuse of genocide convention. So this is a different approach to finding the jurisdiction of the court. And all I've said before connects with the order of the International Court of Justice in this case. And of course, court found that it had jurisdiction prima facie because the court stated that there is a dispute between Russia and Ukraine concerning genocide convention. Simply, Russia is claiming that there is some genocide in the Donbas region. Ukraine says no. The court finds that what Ukrainian seeks is plausible. This is to say that the provisional measures that Ukraine requested are connected with the main proceedings, and obviously this is quite clear for all of us that this whole case is urgent. And on the right-hand side, you can see this order, and the first and second point are what the Ukrainian was asking for. So Russia was ordered to immediately stop this whole military operation. And also in the second part, Russia was ordered to ensure that every forces under its supervision, let's say, must also stop this military operation. The third point is something new, and the court created it. Ukraine was not asking for this third provisional measure. And also it is important to underline that Ukrainian asked the court to oblige Russia to present some reports how provisional measures are introduced. And court didn't agree to order this issue, and we don't know why. Okay, or maybe there is a few sentences in this order, but for me it's not very clear. And also it is important to underline once again that 13 votes to 2 is quite high margin. So there is some consensus within the court. Okay, and now we can come to the fun part, how the Polish media covered the ICJ decision. And it is important to understand that in Poland, most media, both public and private on the left and right, simply copied this article created by the Polish press agency. I think that in every state there is this type of agency like Reuters, Associated Press, or something like that. And simply our media in Poland just copied this article and pasted it on its website or they broadcasted it during media. And because I suppose that not all of you speak Polish, I'd like to draw your attention to 3 points in this article. First of all, its title. The tribunal in The Hague has declared the Russian invasion of Ukraine illegal and ordered it to stop. And secondly, the subtitle, the International Court of Justice said on Wednesday that Russia's attack on Ukraine was illegal. So it's obviously false. The court didn't say that this invasion was illegal because the main issue in these proceedings was whether to grant provisional measures or not. Illegality or legality of this special military operation will be decided in the main proceedings. But here comes the most lovely part of this article. Russia had no right to armed intervention. Ultimately, the ICJ rejected Russian allegation of genocide in eastern Ukraine and issued an interim measure ordering Russia to halt the invasion. It is binding under international law. And there is a quote. The court held that there was insufficient evidence of genocide, and at the same time, Russia had no right to intervene militarily, costing civilian lives and causing a refugee crisis. President Donahue read out the ICJ decision. And first of all, the most important fact. This is a false quote. Madam President has never said something like that during this proceedings. So this is a false quote. I don't know who created it, but this is all false. Secondly, once again, the court didn't rejected these allegations of genocide because this will be decided in the further proceedings. It was only said by the International Court that there are not sufficient evidence at this moment to claim that some genocide is taking place in the Donbas, and also that it is doubtful under Genocide Convention that any state may lead special military operation on the territory of another state. But nothing like this was said by the court. And also there were other articles and some information in Polish media that even suggested that some prosecutors work in the International Court of Justice. So also there is this mixture of International Criminal Court, International Court of Justice. They both are in The Hague. Yes, you know, it's easy to combine it all. And now it's time for the maybe two most important questions. Are these mistakes significant? Of course. A non-lawyer reading such information is simply convinced that Russia has already been judged and the illegality of his action confirmed. But nothing of the sort has happened. Ukraine may still lose this whole case based on this jurisdictional grant, and a lot of lawyers think that this is highly possible, that Ukraine will lose this whole case because of some problems with the ICJ jurisdiction. And maybe the most important question, why has this happened? So I suppose that everyone wants well, and simply everyone is trying in its own way to help Ukraine. And apparently the public and media have zero knowledge of public international law. Unfortunately, most ordinary lawyers also don't know nothing about international law. But I think that we should demand more, and first of all, we should demand that the information presented in the media must be somehow reliable. And secondly, we as young lawyers, we should do something to make public aware what, for example, public international law is and how it works. Because I wrote to Polish press agency and I asked them to change this article, and they answered me and they said, yes, so please correct it for us. So I did it, I resent it to them, but nothing happened. Still on the official website of the Polish press agency, you can find this false article claiming that Ukraine won everything in the International Court of Justice, which of course is not true. And now thank you very much for your attention.
Thank you, dear Milos. I will address my panelists in names, if you don't mind. And I was wondering whether this is misinformation, fake news, disinformation, or something else.
Unfortunately, I have no idea. I don't know who created this information. It was written by one of the Polish journalists in The Hague, and simply everyone copied it because no one in Poland cares maybe about public international law. This is a sad truth, because in Poland there are a lot of programs that simply broadcast what's happening in the world, and at the beginning of this war, nearly none of them featured any specialists in public international law. There were soldiers, politicians, journalists, etc., but there were no lawyers. So unfortunately, this is sad truth.
Yes, really, it's sometimes not an easy task to correct the very best accurate words. In commenting all these things, of course, journalists, they have the duty to present a reliable information, and so all we have certain duties when we comment war, for example, and recently Lithuanian parliament was in a discussion, and also we have the draft amendment for the war propaganda to be criminalized, in addition to the criminalized already such acts as incitement to hatred, to denial of Nazi crimes, and that is why our limits of expression of our opinion about war is limited. So we are not longer allowed to have an opinion in sympathy with the Nazi crime, and this is very relevant in order to stop such atrocities when the hate speech moves to hate crime, as happened most recently in Myanmar against the Rodriguez group. But I want to thank you, my dear panelists, and you saved our time for discussion, and also already the questions are arriving. And I would I would like to start to invite Lilia Timofeyeva, dear Lilia, if you are with us, and also your presentation a little bit was related to the presentation of Vigar Ibrahimov. So, yes, dear Lilia, thank you once more for presenting what Ukraine is facing, the reality that is such cruel, and journalists used to ask many times after Bucha, so how many evidence is needed? Yes, Mr. President, Mr. Zelensky also said, how many still more deaths should we have when that justice finally arrives and we finally have those evidence of crimes against humanity? So really many international organizations, so Organization for Security and Cooperation of Europe presented under so-called Moscow mechanism, presented a report about the violations of international humanitarian law and human rights. And we see there are cruel things that, according to international humanitarian law, occupant regime should ensure at least the basic needs of those people. But we see that in reality, they were sitting in shelters and looking for food and water. It is completely forbidden to target civilian targets, but we saw civilian infrastructure diminished and demolished, and also we saw the intentional killings of civilians riding bicycles. Yes, we saw shelling of houses, kindergartens, hospitals, and drama theaters. According to humanitarian rules of humanitarian law, yes, we should ensure those attempts to identify, to establish the identity of those prisoners of war. But instead of that, we see that they are tortured, they are killed in some cases. We have the demand to cooperate with organization of humanitarian nature, but we see opposite. We see the obligation to support evacuation route, but we see in reality that Russia is responsible for transfer, yes, forced transfer of hundreds of people to Russia and taking away their passports. The people that the fate of whom about whom we do not know. Yes, so dear Lily, I apologize for a little bit long introduction, but I am really focused on those reports, and also the UN mission for Ukraine, monitoring mission for Ukraine is also reporting all those cruel things. And I'm not sure whether you had a possibility. I believe that you did manage to capture the main idea of the presentation, of the second presentation, yes, did by our colleague Vugar, yes, and he spoke about the shortcomings in the UN Charter. Yeah, so I just wanted, perhaps for you to once more to refer how those, shortcomings in the UN Charter could be dealt with, how that exceptional position of Russia is an obstacle when we speak about responsibility for international crimes, when we speak about the crimes against humanity, and any ideas, how to change or amend the situation as we have. And also the same question is for Vugar.
Thanks a lot for these questions. It's really important things about some outcomes about some influences to Russia Federation and this aggression. There are a lot of sanctions provided by European Union to Russia Federations, and I guess these sanctions are not so fast, but actually people in Russia Federation is already felt these sanctions because of rise at prices to some first aid foods, salt, sugar, and so on. Yeah, but oligarchs and government also will feel the sanctions, but in the nearest future, I guess. And what we do, what the world do, it's crucially important. And our integration with all of the world, it's crucially important things. All of the countries help us, and all of the countries do what they can. And it's important in this case. Important to think that we are not a single country, and it's encroach not only on our country, on our territory, but all of the European values and international norms, because these norms was adopted to respond to war that already happened, the World War II, and we hope that it wasn't happened, but it's happened once time again. And it will be a threat for all of the countries of European Union and others, but we can do something. And these sanctions will work in the nearest future, I guess. Thanks a lot.
Dear Lilia, thank you very much for elaborating on this question. And I have a particular question from the audience here arriving to colleague Vigar. Yes. The question is the following. Would you be in favor of eliminating veto vote in the Security Council? If no, how would you propose to make the functioning of the Security Council more efficient?
Yes, thank you so much. That's a very good question. And I am not in favor of eliminating the veto power, and I don't think that the states would accept it. However, how we can deal with this situation, it is, I think, we can, I showed you the article 27, which is talking about this veto power, and there was an exclusion. They excluded the chapter 6, but not chapter 7 under the charter. And chapter 7 of the charter is about the action with respect to threats to peace, breaches of the peace, and acts of aggression. So they didn't include this exclusion in Article 27. And I think if we can amend Article 27, we have to definitely include this exclusion criteria in the chapter 7 under Article 27 as well. So what does that mean? Whenever a permanent member is a party of the dispute which is related with the actions about the war, about the peace, so they cannot vote at that moment. When one of the parties of the dispute is a permanent member, in that case, the veto power should not be, let's say, functioned, should not work. So only other members can decide, only other members of the Security Council should be able to decide on this matter. In Article 27, it is like that. The wording of the Article 7 is talking similar to this wording, but they are excluding chapter 7, which is the most important chapter of the charter. And if we can amend the charter, we have to definitely add this exclusion criteria under 27. And the other possibility already was tried before a couple of years ago. The Secretary General Kofi Annan tried to come up with certain reforms to deal with this problem, and he suggested to raise the number of the Security Council members from 15 to 24. That could be an option as well. I am not sure, because it received a lot of opposite reactions from all big states, saying that no, we shouldn't do that. We have to go to the way we have now. But yeah, if I see as a solution, as I said, to have this exclusion criteria in Article 27. And so somewhere, I also want to say some words about these sanctions. As I said, these sanctions, maybe we can work in a short term, but I don't think that they will work for the long term, because they do not serve the best interest of the appliers as well. I mean, the European Union, United States, and all other states who are following these sanctions. For now, it is necessary, because we don't want another war, another world war. And of course, we need to do something. And the best thing the states can do now is just excluding and isolating the aggressor from the rest of the world. But as I said, any kind of agreement or any kind of act postponing the future potential war is not a solution. We could come up with better instruments, of which I do not have any idea as well. And then for now, it seems the sanctions are the best options. But to me, when I think that this is provisional, these are temporary, and when the war stops, these will be lifted. And so it will not prevent other countries, which happened. For example, Russia did this in 2008 to Georgia. Russia did this to a lot of these other countries in Ukraine and annexation. The world usually afraid use the word invasion. They say annexation, and it is highly likely this could happen easily to my own country, Azerbaijan, because it is right under the hand of the Russia. So, and also this can easily happen to Kazakhstan, Kyrgyzstan, and other Central Asian countries. And if that happened, the European Union is not able to save these countries as well. So the sanctions, when lifted, will not prevent future wars, which could be accelerated, which could be done by Russia to other states. So that is the core idea of my approach. Yes, for now they are working, but they are not the best solutions. Thank you.
Thank you so much, dear Vugar. And you know, the two words that I have highlighted in reading your presentations are ironically and paradox, because you know these two words, they the best reflect the situation that we have. We are like hostages of the international framework, the UN Charter that we ourselves created. And we are like in a circle. One of the reasons is the voting rights within the UN Security Councils, and the reform of the UN is a lifelong story. And as was presented, we had different ideas about expanding the Security Council in terms of member states, yes, about differently attributing those voting rights, and also among the ideas, I found, as you also reflected, that once we have, and this is more or less the recent one, if we have the permanent member, accused of war crimes, of course, there's no criminal responsibility of state, but still, the state is responsible for violations of humanitarian law. In such case, we could not allow to vote for such a member if it is not possible to expel it. And also, international community developed, let us say, the responsibility to protect doctrine, and also among many conditions, we have this invitation for Security Council permanent members not to use this veto power, yes. And, even initially I have noticed that academics, they even challenge the membership of of Russia within the Security Council as such, because it was the Soviet Union and it like inherited, because it's the continuator of Soviet Union, Russia is. But if to take Yugoslavia, the former Soviet Yugoslavia, so we had the collapse of that federation, and for many years Yugoslavia was not with a member of the UN, because the country wanted to be a continuator of the former federation. But international community understood this to be differently. So after many years, Yugoslavia, agreed to title itself as one of those successor states and finally joined the UN in 2000. Of course, this would be too late and too difficult to challenge the Russians' presence within the UN Security Council. And thank you, dear colleagues. Still, I have one question to a very attractive presentation, yes, done by Milos, and also the listeners. They thank you to you for your lovely presentation, and has a question for you. And I just remembered that we used to say that personal data is like a modern currency, and information is like a modern war. Yes, one of those hybrid wars tools, weapons, if to be more precise, when we speak about propaganda campaigns, establishment of separatist regimes, and also influence on election and cyber attacks, and so many forms which make the current modern conflicts different as we used to have. And the situation is different in many terms. Yes, this is not the situation like after the Second World War, when we have those winning states, those who lost the war, and much is also important when we refer to state responsibility. Yes, but turning back to the information and the importance about the truth those times, the particular question is the following. So would you please answer, in your opinion, what measures could be taken to prevent such situations of misinformation, disinformation? What measures could be taken?
Okay, thank you very much for this question, and I think that this is quite a tricky one, because I don't expect that. I think that I also can't expect every journalist to be somehow specialist in public international law or in any type of law, but I think that I have this right to expect that the information published after this whole process, from starting this whole writing process, checking this information up to its publication, that this whole process would be somehow capable of catching these errors. So I think that there should be somebody in, I don't know, in a redaction who knows maybe a little bit more about public international law or any type of law. Because, for example, when we are reading some article about, I don't know, medicine, or chemistry, so there are somebody, I don't know, involved in this field who somehow said something to this author, how this article should be corrected, what we can write more. But I think that in this case, everyone wanted well to somehow help Ukraine and show that Russia has been judged. But the way they did it is not proper, let's say. Because if somebody is not capable of understanding how international law works, he may be very disappointed. Also, in my family, I had to explain it to my relatives what the international code said and why this information presented in Polish media is false. So this is a very complex question, but I think that there should be somebody in this whole process of the publication who is capable of checking if this information is true or not.
Thank you for your comment. You know, some say that to provide the true information, true facts are the best weapon to challenge when we have fake news. But this is a little bit perhaps not so intentional or
because this is, let's say, good propaganda. We are not trying to present something good as something bad as something good, but here we just want to say that we really want to help Ukraine, but we present false information. So that's the problem. So let's say this is good propaganda, if there is something like that, but this is a very complex question. And unfortunately, it happened only in Poland. It's a pity.
You know, you have a very accurate eye on what mass media reports, and but perhaps within a year or so we will have this as a true fact, because really it's a very positive thing that Ukraine managed to take the Genocide Convention as basis for jurisdiction, because in international law we still have this, you know, task to find the case, the basis for jurisdiction, and this is a very specific situation when we take the misinterpretation of the Genocide Convention as the basis for jurisdiction to be taken by Ukraine against Russia. So the main aim is not to be a victim of an erroneous interpretation of this particular convention, because Russia has turned everything onto its head. You know, in addition to that, it's completely denied international law. So it's turned on its head. What I mean is that Ukraine, as you perfectly remember, notified that those mass military forces which were deployed, they were saying that this is only for military defense. Then, having attacked, they said that we are going to denazify and demilitarize. Again, when we had these proceedings before the ICJ, they did not seem to speak much about that you know, denazification any longer, but Russia denied jurisdiction, saying that ICJ did not have it, and that Russia was acting on the basis of the self-defense. But the truth is that Ukraine is exercising the right of self-defense. And the court merely said that, well, it seems that there is more or less, I cannot cite in a particular, you know, words, but more or less, so there is no legal basis in international law. It seems that there is no legal basis which could, you know, how to say, support this right of a state to use a military force in order to protect the citizens from even those international crimes, if they were true. But of course, in this particular case, this is a complete lie. And in addition to the whole history of Russia against Ukraine, starting from starvation policy to denying the right of this nation to have their own country, their culture, and so on and so forth. Yeah.
Can I add something? Because when we are talking about genocide before the International Court of Justice, there is also this Rohingya case, which is very classic, let's say. And when the genocide was taking place over Rohingya people, no one was willing to intervene military. So this only, how to say it correctly, this only presents that Russia is simply lying, and there are using international law to somehow justify their wrong actions. And unfortunately, International Court of Justice had to deal with it, because this is a very difficult case, even for these judges, because let's say I also read dissenting opinions of the Russian and China judge, and you know, these opinions are not rubbish. There is some sense here, but it was a very difficult task for the majority of judges. How to say that this convention can be used as this basis for the jurisdiction prima facie?
Thank you. And to continue, really, those allegations that we usually hear from Russia that it is allowed to protect citizens using force under international law. So really, I just would like to remind that under the UN Charter, we have the two, let us say, exceptions to the general prohibition to use force. The first one is the UN sanction. So the authorization as the final results when no sanction, no calls for withdrawal of troops, nothing else, no negotiations, and no other peaceful measures help. So the other one is the self-defense, yes, and in practice, and this is a separate story, we had that modern form of humanitarian intervention as the responsibility to protect doctrine, which was developed after the failure of the UN to respond to what happened in Srebrenica, in Rwanda. So then the Security General just posed the question, so if this was the assault to sovereignty of a state to use force in such cases, so how to deal with such cases if nothing else happened. But this is, of course, a separate topic that should be presented with all details and requirements for the responsibility to protect doctrine, which is mainly developed for protection of the citizens of another state from those cruel regimes when we have only crimes against humanity and when all conditions are exhausted. But this is not what Russia is invoking, and also international law does not like much historic religious claims. You know that many decades ago Ukraine was part of the Soviet Union, and so what? So we are not longer in the Middle Ages. After the Second World War, we had the new, you know, framework of principles in international law, due to which we used to say that we used to live more or less peacefully throughout these decades, particularly in Europe. Of course, we had war in Yugoslavia, we had conflicts in other regions, but more or less, due to the principles that have been completely violated, all of them, by Russia, of international law and also the principles of international and humanitarian law. And so, dear panelists and dear colleagues, I'm very pleased to have you all here, and I thank you cordially, really, for Vagur, for dear Lilia, and also for Milos, for your perfect presentations, for saving the time for our discussion, for those who listen to us, and for your questions. I just wanted to finalize, to summarize the results of our session, because I believe that throughout the whole period of the war, we talked much about the need for unity in expelling Russia from all formats, starting from sport competitions and ranging to you know, international organizations. And the other issue was call for accountability, justice, in order to save the further generations. And I believe that our contribution, let it be, you know, modest, but still is a contribution to this movement, which I hope would be more wide and more fast, globally, regionally, looking towards and striving for the accountability and having justice to arrive not too late, and that the victory of Ukraine does not demand a price that is too high. So thank you once more, and enjoy the other sessions of this conference. Have a nice day.
Participants to keeping up with the schedule. That's very important in conferences, I think. So for the guests and viewers, I declare now a lunch break. So we will be back at 1 p.m. Precise time, and we will go on to continue with the session 2, questions about public law, globalization, and digitalization. And for our participants, I would like to invite you to have a lunch together, which will be held in a restaurant over there. So you have to walk out the room, turn to the right immediately, then to the right again, then go straight, and on your left side you will able to see, or you will follow me. So thank you very much, and see you soon. So welcome back, everybody. So I invite the presenters of our second session, questions about public law, globalization, and digitalization, to have a seat. Okay. So Vigita, the floor is yours.
So good afternoon, everybody. It's nice to see you after lunch. And we continue with the second session of our conference. The session is called Questions about Public Law, Globalization and Digitalization. So we will have 6 presenters. I am glad that 4 of them are in person. We can meet them and speak face to face, and 2 of PhD students will be online. They will present their topics online. So I'm glad to invite Karolina Mickutė. She is a PhD candidate from Vilnius University, and she will speak about the consumer or the trader who decides on how a product is used. And I would like to invite you, everybody, to have your questions prepared, to write them down if you have. And I also invite persons who are watching this event online also to write your questions on Facebook or on YouTube. So, Karolina, the floor is yours.
Good afternoon, everyone. I'm so happy to be opening the session today. Thank you for the organizers for having me here. So I think that you want something more like chillaxing or something after the lunch. So I try not to use too much science, but still we have to talk. Yes. Дякую. Super. So I'm Karolina, and this question here has been haunting me for the past 2 years. The consumer or the trader? Who decides on how a product is used? If you have never thought about this, I hope that at least after today, you will in those awkward moments when you're driving your car and it's like, oh my God, who does decide on this, So I'll start, I invite you to get warmed up with a very simple thing, So we have on the left the super ecological, super sustainable razor. And possibly, I know that most of us have used it to remove lint from your sweaters. That's quite, that's easy. Basically, our mothers tell us to do so. However, in this slide, I was so bamboozled about the possible 50 ways to use Coca-Cola. So intended thing was to be not original. Original was intended to reduce hangover effects, but then they removed the cocaine and so on. So it's used to drink primarily, right? But did you know that you can add volume to your hair because just for rinsing your hair with Coca-Cola? So I didn't know that. And then you can actually reduce it has health benefits because it reduces the risk of kidney stones. Incredible. I love to see your enthusiastic faces, we all need an injection of Coca-Cola right now. You can also clean your toilet. Just let 1 can sit for an hour before you use it. You have used it as well. No? For sure. Yeah, and the most impressive thing is you can actually give yourself a tan. Just simply spray it on your skin before hitting the sun. I think that you could turn into a beehive after it, but just, let's see. I'm super intrigued by this. And here on the left, we have mouthwash. What? So yeah, apparently in the Central and Eastern European countries, it's quite topical to drink surrogate alcohol. This is actually a part of my, landscape exploration, empirical research. I bought this mouthwash, this bottle, that's the actual size for sure. And I bought it in an outskirts, in a suburb, little small town, kiosk, and it was in the same line with the beers, vodkas, antifreeze, and eau de cologne. So, okay. And after I was traveling to a smallish town around the Vilnius outskirts, and it was a picture of the same the product, being completely emptied out near a bus station. So I have serious doubts whether it was like 5 people stood and rinsed the stuff out of their mouths, and just poured it out. So that has to do, the scientific part now has to come in symbolically. I'm analyzing the directive 92/83/EEC, which deals with the issues of providing harmonization on excise duties on alcoholic beverages, and also has these certain exemptions that are super problematic. It's particularly the Article 27.1.b, which says that you can refuse relief access taxes if the product is not for human consumption. So I'll get into it later. And then I noticed that case. I got so, I'm obsessed, what is not for human consumption? So after 22 years after the directive was enacted, the Commission came to understanding in 2014 only that this directive does not correspond with the developments and the challenges they pose for the alcohol sector. Thus, a review is necessary. It took them 6 years, just a spoiler alert, it took them 6 years, but I'll get to this in the next slide. So I have 3 points to make today. I believe that I found actually that changing the laws won't benefit the European Commission's goal to harmonize excise taxes. The second point, maybe the courts can help, and I found that the courts can help, cannot help, because they have very various and concurring arguments in similar cases. And the third part, I started looking for inspiration in unorthodox ways, and I discovered the methodologies of post-Keynesian or mainstream economics and Austrian economic law theory, which is the mainline economic theory, can help actually to ensure a uniform and just interpretation of the directive. For further reference, when I speak about the directive, I talk only about this article here that allows the exemption to be made. So the first question we must think about is, does changing the law work? And yes is the answer. No, I'm joking, it's no, it's not no. So the experts found that the exemption, the article of the directive, is particularly complicated and it provides a lot of ambiguities. And it took 6 years of deliberations on finding the possible means how to solve it, and the welcome. And the European Commission issued a new directive that had the exact same wording, not for human consumption. So after a huge going through the ex post regime, the review process, they're still left with the same formulation. So when I've started thinking about the legally, practically thing, let's do a systemic, linguistic, and teleological analysis of it. So I found that people are lost in translation and in consumption. First of all, in the French and Lithuanian versions, there's a huge emphasis on the intention of the trader. So they state basically that something can be relieved of excise taxes if it's not in a product that is intended for human use. The Lithuanian version adds a new perspective, which they say that, I'm at this point, that first of all, there's a criteria of not being intended to be used, and it's not a product of, it's not foodstuff. So they even narrowed the whole concept of it. Whilst in the official version, which I believe has the primacy of interpretation, they state that the product is not for human consumption. That's it. So we walked a circle, and now we have, and now what we have is at least 3 different linguistic approaches to it, even after ex post review and so on. So I found that this does not ensure the goals of harmonization. Now I tried to find some help from the courts, and the courts have indeed engaged in analyzing consumer behavior, but the case law is completely selective, fragmented, and used quite lazily when it's more convenient. In particular, I used 2 cases as a case analysis and comparison. So sorry for the people from the Nanterre, but in the Répétoire culinaire case, oui, merci beaucoup, the court engaged in the court's assessment was based on how the consumer behavior, how the consumer would behave towards the product, meaning that it is undrinkable, and that's it. The case considered wine, like a wine product mixed with salt and pepper, and said that it's undrinkable. Whereas in the benefactum case, the court decided that the trader alone can decide on the use of the product, and the consumer behavior is completely irrelevant, even though Lithuania, Lithuania put the case before the court. Lithuania stated that there is evidence, there's hard facts that it is indeed used as surrogate alcohol based on research and so on. And the trader himself, he stated, yeah, we know. Yeah, so see, this is why it's peach flavored. you know? And so the benefactor, why I put a significant emphasis on this case, is that it's the first case on surrogate alcohol consumption. And what the court actually did, I think it failed its test because it actually legalized fraudulent schemes in selling surrogate alcohol, which is completely contrary to EU's goal to prevent health risks and to ensure the rule of law. Could you please raise your hands if I'm talking too fast? Because one person told me that I may be from New Jersey. So, and then if so, the conclusion that I draw is that the court cannot help us because it selectively uses its approaches and there is no homogeneous rules on how decisions are made. Then I started looking into mainstream and mainline economic theory. Perhaps it could come into rescue. Why I started thinking about this, but because in one case, the court actually engaged in behavioral economics in the repertoire case, as I mentioned before. And the leading mainstream legal economic theory now is the post-Keynesian theory, which is actually, the key points of it is that the consumer is super rational. And when he decides on some kind of cases, they analyze a huge, vast amount of aggregated data for that. So, and also the European Commission also uses the Keynesian theory because it it selects a certain, if you disagree, I'll wait until the end because, because when the C says, when dealing with competition issues, you have to look into, first of all, the geographical market, for example, Eastern Europe, North Europe, and so on. And further, if you want to deal with competition issues, you have to look into the product market. Whereas contrary to that, I believe that it's it's an easy way to analyze aggregate data, to look for middle grounds and so on. But the Austrian or mainline economics quite disagree with this, stating, and what I find it a lot more compelling though, is that they use this method of methodological individualism, stating that there is only one market, one global market, there's no digital market, there's no alcohol market, it's only the people the people decide on what the market is, because it's all based on human interactions and decisions on how they to spend their opportunity costs and others. So it also criticizes post-Keynesian theory because they said that it's the supply and demand, which is constantly used by bankers and like mainstream economists in Lithuania as well. They rely heavily on the supply and demand factor, whereas the Austrian school of thought says there is the supply and demand is actually an aggregate, is a fictional aggregate. I want you to let it sink in because it super makes sense, right? When a person makes a decision, for example, let's say in the primitive surrogate alcohol case, as I mentioned before, I bought the product in a kiosk where it was standing like the mouthwash, vodka, I think, antifreeze, and so on. So let's imagine if something like a market fluctuation happens and there is no more mouthwash to drink. So the person there, I believe that he would not start like how we choose alcohol. For example, if the second beer is cheaper, I would take the second beer. I would not like how the post-Keynesian, I would look, oh, sorry for the microphone. I would look from a far perspective and think like, what are my long-term goals on this cocktail? Should I do a mimosa? Maybe, oh no, they don't have cava, so I cannot make a Bellini, and so on. No, I believe that the person, when I'm choosing, for example, dry sparkling wines as an example, I choose the one that is cheapest or the next in line to my preferable one. So this, I prefer Brut Natur, so there's only like one brand that I like specifically, but if it's not available, I'll take the second Brut Natur in line. I will not like think, what are my goals? Like, you know, from the supply and demand kind of perspective. And I find it most compelling, and I believe that this methodological approach to consumer behavior, it could actually provide a deeper insight on the human and how he acts in the world for real, not in an aggregated fictional model. And I'll invite you next year, because I'm running out of time, or I will give a presentation on how the WTO court applies consumer behavior methodologies. Basically, look into not only objective criteria, taste, smell, placement, so on, and ingredients. They look into subjective competition criteria, which is, for example, for what purpose is the product typically used or used by a certain group of people. For example, in dealing with the product classification case, the WTO decided on that 2 alcoholic beverages have to be taxed by the same regime because they are used for the purpose of intoxication. Sounds quite simple. Just to quickly run through for the argument, I know the time limit, so as I mentioned before, priorly, I believe that a key element in the benefactum case was that the trader himself said, yes, I know that my mouthwash is being consumed and ingested, and I will tailor the packaging of the product intentionally as that. So taking a far more glance from the perspective of the EU's development and so on, I believe that in the benefactum, what the court did, it actually legalized fraudulent schemes. So if you just want to sell surrogate alcohol, you just have to slap a label that says it's like screen wash, whatever, and so on. And that's particularly contrary to the EU's goal to prevent harmonized application of excise taxes and to prevent health risks. So changing the text will not change everything. The case, we cannot seek any help from the Court of Justice because it's super picky and fragmented in its application of the rules. Mainland Austrian better answers the questions. What is super important thing, particularly in the surrogate alcohol case, is the creativity of the person, because when a rule is created, the person would typically find a way around it, And thus, I think that it would be prudent to include this methodology and the consumer behavior deliberations in the court making decisions, particularly on product classification as to be relieved of excise taxes. And I invite you to the discussion afterwards, and if you're too shy or don't have any ideas right now, feel free to contact me via email. I would love your input. Thanks.
Yeah, so thank you, Carolina, for your presentation. And the questions will be at the end of a session. So the second speaker will be online. Do we have her? It's Daria Bulgakova. She is a researcher, works now at Vilnius University, but she is from Ukraine, and her topic will be completely different. So her topic is the case study about facial LISM identification under GDPR Article 9. So do we have Daria?
Good afternoon, everyone. Can you see my PPT and hear me as well?
Yeah, we can hear you, and we see your presentation.
Great, let me start. Okay, thank you so much for introduction. Good day, everyone. My name is Daria Bulgakova, and my pleasure to present a work, a case study about facial aliquot modification on the GDPR Article 9, Para 2.g, done in China at the University of International Business and Economics at the Faculty of Law in Peking City. The legal field of the study, the personal data protection law of European Union. The request to study this matter is reasonable because the personal data protection significance builds a trait to meet a legal challenge of emerging biometric business growth. Thus, the actuality of the proposed study has been formulated by increasing popularity of unique identification for digitized legal identity. Biometric data, a particular category of personal data, is explicitly prohibited for processing based on Article 9, Para 1 of the GDPR. Despite that, the controversy is given by the subsequent rule of Para 2 that allows the process of biometrics. A study explains that prohibition requirement by the high level of personal data protection under fundamental legal framework. On the other hand, to allow the process, a study considers the explanation that the right to personal data protection is not absolute. Therefore, the Charter of Fundamental Rights of the European Union in Article 52 requires biometric data processing to be a subject of the principle of proportionality. Talking practically, the facial identification to prove who the user is through the aliquot platform is the groundbreaking experience that occurred in France. That creates a studied box of problems to be solved when the process of biometric is prohibited, and on the other hand, when it's allowed. It is essential to be solved because there's a risk of disregarding the specific type of personal data as biometric by its nature. It is relevant because the specification of how biometric data processing shall be operated according to the principle of proportionality is neglected. Having appointed a box of problems to be solved, the study expectation is to come up with three categorical outcomes that following questions: what is prohibited, what is risky, and what is allowed. Through such a design mechanism, the study states that biometric data is processed according to the principle of proportionality that is equivalent to the rule of traffic light exploitation. Based on the principle of proportionality application, a study found the way to comply, and this includes the next criteria: action. Relies on a categorical apparatus processing, has an immersive, automated, command-based operation and machine-readable design that deployed for physical, physiological, and behavioral characteristics of a nature person with a biometric data outcome. Form of action. Based on European law, only two forms of processing are approved and defined by law: the dactyloscopy data and facial data. Content of action. To identify back the source of biometric, supplementary person provides other personal data about him. In this regard, the technical and organizational measures is a content of action. Goal. Goal is unique identification where the processing must respect human dignity. The reprocessing of biometric about what a person is unaware leads to unproportionate processing. Thus, unique identification must be under the trust of the parties involved for that goal that's relevant to the moment of automative implication. Interest involved. The legal relationship includes the interest of one party lawfully employing biometric technology over a human source, and the interest of the second party is to have the legal protection of human origin. The principle of proportionality is performed giving a person a quantified self-status. This capability is significant for the protection because biometric employment could replace a human and build a uniquely identical prototype of a person that, in the view of European law, goes against human dignity. Thus, the principle of proportionality is applied here to measure the force of algorithmical quantification of the human-centric decision-making role, where the person is free to act as a valuable legal unit. Because biometric data process reveals details about individuals in ways that are qualitatively different from single instances of biometric characteristics, therefore a warrant requirement for a person is necessary. Hence, biometric data processing would have a high level of protection impact if pseudonymization and encryption technical measures were taken. Besides, to keep the goal pursued, a study proposed to solve the misunderstanding in the legal theory of GDPR technology used. To receive the outcome for unique identification, lawyers must differentiate authentication, identification, and verification techniques that is on the example of the France. Based on the example of France, it is found out that all of them can achieve unique identification. However, a study states that only verification process is sufficient for business. Other techniques are not because it humiliates people. A study refers to Alicam as example based on the exception provided. The Alicam is allowed platform because the processing is necessary for substantial public interest, which is proportionate to the aim pursued, proportionate to the essence of the right to data protection, and provides suitable and specific measures to safeguard the fundamental rights and interests of the data subject. France reconsidered the digitized legal identities through the facial recognition. In this regard, in May 2018, France adopted a decree that authorized the unique identification and allowed the facial identification based on the exception provided by GDPR, Article 9, Para 2.g, through the Alicam tool for smartphones. On the other hand, the National Commission for Informatics and Freedoms disagrees that this novel rightfully complies with the principle of proportionality. However, in November 2020, State Council dismissed request of mentioned commission because Alicam system complies with the principle of proportionality. The study found that the compliance based on the next elements. The first one, the processing of biometric is for public service. Second one, a person is freely given agreement. Besides, it respects human dignity because of the minimum reliability and accuracy of the algorithmical used. Alicam is recorded on the user's mobile equipment by using the NTAs with a central server, and this sharing allows the person exclusively control the storage. Moreover, biometric data is necessary and proportionate to the purpose because it is an offer for French and foreign nationals to identify themselves electronically. The conclusion was based on the proposal call of the study, regardless to the completed answers to research questions. no biometric data without knowledge of the data subject. Use for incompatible purposes and reuse of biometric has to be forbidden. Biometric application shall not be based solely on automated decisions. No combination with additional personal data is possible. An explicit prohibition on processing biometric in central databases. Limited exceptions are determined by law only. Prohibition use of biometric system for unique identification without explicit law. Consent and choice of the data subject. Transparency for the data subject and role of certification. The data subject recommended to receive an information about how the data is processed. Besides, deletion of biometric template has to be granted by law. The protection of biometric have to be granted in pseudonymization way. Biometric data processing for business requests requires additional legal basis. The processing of biometric for strict public necessity based on the law of particular country. The study also recommends to pay attention to the next statements. Have to be the distinctions of process and finalities, and there have to be some legal establishment about this. In the view of the study, the protection have to be applied before, in the process, and after biometric data processing. Second one, user verification by business is appropriate. Revocability measure could protect against identity theft and misuse. An alternative identification shall be granted by law. The trust is not in all cases reliable ground. And the last one, the distinction between characteristics that fit races and do not is outdated in European Union law. Thank you so much.
So thank you, Daria, for your presentation. And I hope someone will have questions for you at the end of a session. And the first presenter will be Mikhail Bishinsky. He's from University of Lodz, and his topic is AI governance, old wine in a new bottle, ? So please, the floor is yours.
Thank you very much. My name is Mikhail Bishinsky. I'm a PhD candidate at the University of Łódź in Poland. The topic of my speech is AI global governance, the old wine in a new bottle. How do I understand this topic? What is a bottle and what is a wine? A bottle is AI technologies which pose some threats and dangers to international law. In particular, I mean human rights law, as this is the field of my particular interest. But the old wine is something very essential to the international law. I mean some basic principles, characteristics of international law. Ladies and gentlemen, application of AI, of artificial intelligence in business, government, or just in everyday life have been developing in a breakneck pace. It is really fueled and influenced by powerful computing hardware, some data, online training of machine learning. International relations, global security, diplomacy are especially likely to be profoundly affected by this development. And many people, many organizations and states, they are trying to anticipate this process in order to stay safe in these circumstances. However, the level of AI readiness by governments and companies will have a dramatic effect upon competitiveness and will probably become a critical factor in investments and economic growth. AI-driven industry automation in developed countries of labor-intensive jobs could arguably displace these traditional comparative advantages of developing countries, for example, such as a cheap workforce. a widening gap in prosperity and wealth would mostly affect those countries which are unable to develop digital skills and infrastructure to reap the rewards of AI opportunities in the field of productivity and innovation. If not long ago global inequality was determined in terms of have and have-nots countries, a new divide could be emerging between AI-ready and AI-not-ready countries, which is something new for us. And we should take steps in order to prevent some danger situations. There are some concerns about AI, and those concerns are focused mainly on long-term trajectories and near-term trajectories, which in my opinion are of paramount importance. And what I mean by near-term trajectories is, for example, some regulations, policies, technical guidances, technical standards, steps. And the fundamental question that is to be asked now is whether there is an organization, or for example, whether the UN is the right organization that can successfully articulate both of these trajectories and become a body that is proactively going forward, despite some considerable skepticism about the, let me say, effectiveness of the organization in the field of international law as such. Some experts have been wrestling with policy dilemmas so that AI governance can work for all societies. In other words, can it be universal? Can it be unified, or should it be unified? To many of those experts, to-do-nothing policy is not an option. It's hardly an option. We are driven now by a logic, let me say, AI race, and some steps should be taken immediately. Certainly, the question of predictability by means of norm setting is not just a question of inducing good behavior of states or protecting the weak from the powerful. Rather, there is a matter of building commonly accepted rules that can be applied for all, despite some differences between different states or regions. When it comes to laws, norms, regulations, the AI landscape today is fraught with fragmentation. And in my opinion, this is the most problem of this topic. It is worth asking the question whether a fragmented international governance could be effective, or, not being the case, whether there is a need for a centralized international organization. It has been argued that there is some risk of creating a slow and brittle institution. Some experts would say that it speaks against the main idea. However, in my opinion, the problem is somewhere else. The problem is whether, in the light of, for example, what is happening currently in Ukraine, whether the world is capable of creating a body that can be effective in general. Despite the relative lack of clarity, it should be expected that AI governance one day will go somewhere global, and it will require more and more global coordination, as the problems of AI are already global. Research and policy proposals on this topic are beginning to shed light upon the likelihood of international cooperation on transformative AI-related issues, incentives needed for the parties to reach meaningful agreements, some proper conditions for compliance, or non-cooperative measures. Another proposition aims at creating a new body which is which may be similar, for example, to the UN Intergovernmental Panel on Climate Change, IPCC, to give policymakers some technical, neutral assessments subject to review by states, underlining the opportunities, implications, or just potential risks of AI, always through evidence-based research by tech and scientific community. And this is the most important thing, I think, in this body. Civil society organizations have been putting forward numerous proposals on principles and AI ethical frameworks, including the landmark 2017 Asilomar AI Principles, championed by the Future of Life Institute. The paper surveyed dozens of contributions around the world on normative guidance in ethical and right-based approaches to principles for AI. Linking government and business network, the World Economic Forum has been bolstering public-private partnerships on the fourth industrial revolution and the future of technology governance. Some countries are already taking actions at the bilateral and regional levels in a move that can accelerate the transition from private stakeholder initiatives to governmental policymaking at the global level. For example, in December 2018, Canada and France bilaterally proposed a global partnership for AI to support and guide the responsible adoption of AI that is human-centric, was what's important, and grounded in human rights, inclusion, diversity, innovation, and economic growth. Their ultimate, I can say, goal was to create a standing forum involving governments, the industry, the academia, just to monitor, just to debate the policy and the implications of the policy of that is taken to govern the AI problems globally. Some major players, however, as China and Russia, are often absent from the discussion. Where is China? Where is Russia? We know where they are. We really know. But the problem really concerns both China, Russia, Canada, the US. It is global. So this is one of the reasons what I think that the global governance on this issue is highly recommended and it's highly needed. At the global level, there is a wide acceptance on general ideas, but a little agreement on the details on how exactly these ideas, these general rules, should be interpreted, prioritized, or implemented. Moving from soft law to hard law regulation will be a really tough nut to crack, especially when the goal is to frame a regulatory policy before the technology is fully understood and developed. This is another problem. Greater inter-stakeholders cooperation is deeply needed to mutually support different AI ethics agendas in key areas, such as transparency, accountability, fairness, privacy, responsibility. I am aware that I am running out of time, so I will briefly conclude what I've just said. On a closer inspection, AI governance is not about regulation or imposing restriction, but it's about encouraging prevention. It's about horizon scanning. It may take more time than expected for the international community to start moving towards consensual measures on AI policy making. However, the problem is, in my opinion, is also somewhere else. As I mentioned on the very beginning of my speech, the problem is whether we are able in general to create such an instrument that can be effectively exercised. We know what happens in the Ukraine. And we know what was the reaction of the whole world some time ago when there were signs what Russia can do, what Russia may do in the future. What was the world reaction? In my opinion, it wasn't satisfactory because of different reasons, and I'm here not to discuss those reasons. But the general issue I want to underline is that whether are we capable of creating such instrument? Please have a look on, for example, regional systems of human rights protection. There is no a global one. We have 3 or 4 main human rights protection systems. Why? The problem is old, as I mentioned on the very beginning. The problem is old because we have no, let me say, mutual ground, but we have to look for such a ground. Thank you very much.
Thank you. So all the presenters are really in time, so we will have time for discussions. And the 4th speaker is Antonin Guillard. He's from Paris-Nanterre University, and his topic is the convergence of judicial and administrative electronics investigation techniques in French law. So please, the floor is yours.
Yes. Just here? Yeah. Okay, thank you. Hello everyone. Today, I'm a PhD candidate of University Paris-Nanterre, and today I would like to present you the convergence of judicial and administrative investigation techniques in French law. French legal system knows a major distinction between administrative and judicial policies. The identification of their respective domains is mainly based on a finalist criteria established by the State Council. An administrative police operation occurs when a general surveillance operation is conducted. In contrast, a judicial police activity is carried out when the operation's object or goal is to seek a precisely defined offense. In the first case, it's mostly a preventive objective which is followed, whereas in the second case, it's more generally a repressive finality. The knowledge of a disturbance of public order constituting a criminal offense and the search of information about the offender justify recourse to mechanisms interfering with liberties. Intrusive and especially coercive acts are in principle excluded in administrative law because the position of the suspect person on iter criminis is less advanced. The person may think about the offense, elaborate it in various ways, but there is no sufficient information, manifestation of an action against a protected social value. On this basis, the legislation has been giving to the judicial police a clear advantage in terms of investigative capacity for a long time. It has thus integrated several technical investigative measures since the beginning of the 21st century. This to fight mostly organized crime. These acts are characterized by their confidentiality, intrusion into privacy, also by their complexity and efficiency. Without drawing up an exhaustive list, it's possible to mention geolocalization, access to connection data, and also access to stored correspondence. The techniques of administrative prevention of threats to the nation's fundamental interest have been kept in an embryonic state during this phase of judicial growth. Intelligence services had few prerogatives and sometimes operated in the silence of law. Intelligence law was nevertheless improved for the second half of the 2000s to avoid this pitfall and to respond progressively to the terrorist threat. Now, reading the dispositions of the Criminal Procedure Code and the Interior Procedure Code relating to investigative techniques leaves a strange feeling of proximity. Some authors state that it's normal for the administration to use intrusive procedures. Others even point out that it's rather believed that particularly intrusive techniques are the prerogative of intelligence services. This is surely not a reversal of the role assigned to each police, but perhaps an overlapping of them, or for part of the doctrine, the emergence of a para-criminal procedure. The most effective way to check this new procedure, this emergence, is to compare the techniques permitted in the two domains. It will allow us to determine the nature of the interaction between the disciplines. Is there competition, complementarity, unilateral relationships, or mutual influences? We will proceed in 3 steps. First, the appropriation by administrative intelligence of judicial investigation techniques. Second, the inspiration of criminal procedure by intelligence law. And at the end, the takeover of intelligence on the most complex and intrusive acts. First idea, the appropriation by administrative intelligence of judicial investigation techniques. The lawmaker often looks for a way to extend the scope of investigation techniques to new procedure. To achieve this, it has 3 quite effective levers. It can extend the technique reserved for instruction to the investigation phase. It can also adding offenses to a category submitted to a stricter procedural regime. And it can also transposing techniques of derogatory regimes to ordinary law. On the sidelines of these different mechanisms, which only concern the Criminal Procedure Code, a new channel of diffusion seems to be opened since the adoption of the law of 24 July 2015 on intelligence. For part of the doctrine, the penal coloration of intelligence techniques remained unavowed or even rejected with the support of the Constitutional Council. However, the Parliament's intelligence delegation has advised that judicial techniques should be transposed into administrative law, and after their integration into this field, get very happy, welcome this new legislation. An examination of 2 techniques confirms this hypothesis. This is access to computer data and recording of sounds and images of certain places and vehicles. First, access to computer data is framed by the Criminal Procedure Code since 2011 and by the Interior Security Code since 2015. The name of the technique is the same in both legal instruments. The take it is executed is also described in a very similar way. It takes place at distance or on the spot without the knowledge of the involved person. Regarding the information collected on the targeted terminals, the drafting of the text is once again comparable. The data concerned are those stored in the systems, but also those displayed on the screen, entered via the keyboard, and transmitted or received by the devices. The proximity of the legal systems leaves no doubt. Also, it should be kept in mind that there are some differences. Yes. A principle of subsidiarity should be respected in administrative law, and the agents and the authorities responsible for control are different. Well, the defense of the identity of the legal systems must be set aside in favor of the idea of quasi-gemelity developed by the doctrine, which is reinforced by the study of another investigation techniques, the recording of sounds and image of certain places and vehicles. This technique is in the Criminal Procedure Code since 2004 and in the Interior Security Code since 2015. It's once again a secret technique, this time based on the use of a miniaturized device able to record and transmit data. In both legal systems, this includes private or confidential speech and also images from a private place or from a vehicle. The specificities mentioned earlier are also valid for audio and image fixing technique. Despite this, there are important similarities between the two domains that show intelligence services have borrowed intrusive techniques from the Criminal Procedure Code. However, the relationship between the two domains is less and less unilateral. Indeed, well, it appears that the legislators now adopting techniques from the Interior Security Code for the benefit of the criminal law, the Criminal Procedure Code. Second idea, the inspiration of criminal procedure by intelligence law. Intelligence law is not a simple copy of criminal law applied to organized crime or terrorism. Some techniques, such as implicature, have no judicial roots. Judges and investigators have noticed this situation and have protested against these disparities in favor of preventive services. In their opinion, it was not understandable that the powers available to track down offenders were less than those available to prevent threats from occurring. The government and parliamentarians were sensitive to this argument, and they have supported the inclusion of implicature in the Criminal Procedure Code. This concept describes a fake mobile relay tower that replaces, in a specific area, the operator's relay antenna to catch informations of the mobile terminals. Part of the doctrine has welcomed this atypical interaction of preventive and repressive law in a rather positive way. However, some hesitations persist because difficulties noted in the Interior Security Code have been partly transposed into the Criminal Procedure Code. For example, the legislator did not consider necessary to define the name of the investigation measure with precision. The modalities of execution of the technique are similar and less contested. And in both legal regimes, it's possible to collect connection data, localization, hour, connections, and also the correspondence exchange under stricter rules. Despite some specific characteristic, there is, you can say, a concurrent convergence between the legal frameworks. It's possible to speak about convergence because the same mechanisms are allowed in both domains, the same techniques. It is also appropriate to speak about concurrence, science, a competition for the most modern and complex measures is underway. In this dynamic, it's necessary to note that the intelligence services seems to progressively take the lead. It's a last idea. Last part, the takeover of intelligence on the most complex and intrusive acts. A group of 5 techniques recognized by the Interior Security Code is not included in the Criminal Procedure Code. The surveillance of international electronic communications does not really seem to interest the judicial services. On the opposite, the other procedures c'est mis en veille. Okay. On the opposite, the other procedures could contribute to the conduct of criminal investigations. Even if some members of the parliament deny it, interceptions on radio networks, satellite interceptions, immediate access to connection data, and algorithms are able to provide clues to investigators. The intelligence services have, in a way, an advantage over the judicial police services because they are the only ones to use these techniques, which have 2 characteristics. On one side, they are complex because they require high-performance computer and assistance of especially qualified agents. On the other side, they are intrusive because they allow access to the content of communications or to large data flows analyzed in real time. The study of the algorithm is the best illustration of the laws of gradation between preventive and repressive investigations acts. This technology allows for a general surveillance on traffic on networks with a software that acts as a filter. For the Parliament, this technique is submitted to an especially strict legal frameworks. But for the National Digital Council, there is a lot of problem with these techniques, which have been tested with difficulties in the US. For the doctrine, it marks a loss of human control over investigations. Suspicion can be based on an equation leading to a quasi-certainty of the detectives. Prevention also seems to become prediction. It's not longer a question of following a dangerous person, but of searching a mass of data to find indications of a potential attack. To conclude, these different dots reduce the probability of algorithm extension to the Criminal Procedure Code in the near future. The intelligence services have access to a more invasive instrument than judicial techniques, even though they are only responsible for threat prevention. Well, the relationship between the judicial and the administrative police is therefore established on 3 levels. First, criminal procedure is a source of inspiration for the Interior Security Code. Second, preventive law influences repressive law. And at the end, the competition between the 2 domains is particularly advantageous for intelligence law, which exceeds the methods of the criminal law system. These exchanges have 2 major consequences. On a theoretical level, the occurrence of a crime, of an offense, is no longer the determining criteria for the use of techniques affecting liberties. And on a practical level, the division of procedures over time is less clearly defined. a preventive procedure can continue for more time because it's no longer necessary to initiate a judicial procedure to execute intrusive investigations. Thank you.
Thank you very much for your presentation. Yeah, and the next speaker will also speak about criminal justice. So he is Pierre-Louis Souton. His topic is evolution of human rights in the light of the McDonaldization of criminal justice systems. He is from Paris Nanterre University also.
Hello, everyone. I am pleased and honored to attend this wonderful conference. And indeed, I will be speaking about the evolution of human rights in the light of the McDonaldization of criminal justice systems. Now, after the great lunch we've had, it's quite inappropriate to be talking about McDonald's. Not that I'm criticizing the quality of their food, but it's something else. Let's face it. Alongside the process of globalization, from which no state can escape today, it appears to be an underlying Americanization of the world, which is reflected essentially in the worldwide export of the American industry and capital, but also of ideas, customs, and habits. And among these habits, the American sociologist George Ritzer has highlighted the spread of fast food chains, which, according to him, is less a sign of the generalization of a way of consuming than the implementation of a way of thinking. Indeed, Ritzer observed that societies today have gradually abandoned a traditional way of reasoning in favor of more rational ways of thinking, similar to fast food chains, which rely on efficiency, cost-effectiveness, predictability, and the idea of control, namely the use of non-human technologies. Described as McDonaldization from his book, The McDonaldization of Society, in reference to the famous multinational fast food corporation, McDonald's, this phenomenon of rationalization is affecting, as he says, quote, more and more sectors of American society as well as the rest of the world, due to the cultural homogenization, resulting itself from globalization. Indeed, the American justice system, as well as the rest of the world, including us then, such as European legal systems, are also concerned by it, particularly regarding their criminal justice system, which are increasingly under the influence of this process of McDonaldization. The more or less recent use of guilty pleas for individuals and legal persons, the use of sentencing guidelines, and the increase in predictive justice in criminal matters reflect the key aspect of McDonaldization mentioned above, namely efficiency, cost-effectiveness, predictability, and the use of technologies. However, this streamlining trend harms the human rights placed at the heart of the criminal procedures in general, such as the right to a fair trial, the right to an independent and impartial tribunal, the presumption of innocence, or again, individualized punishment that exists in some European countries. So what I will do is I will examine this harm done to human rights, and each time take those four aspects of the McDonaldization described by Mr. Ritzer. First of all, efficiency. And I named that, and I entitled that aspect, plea bargaining is the new black. According to George Ritzer, efficiency is about choosing the optimal means to an end, and increasing efficiency usually involves streamlining various processes, simplifying products, and allowing customers to perform tasks formerly done by paid employees. Given the significant stock of cases handled and to be handled each year by US and European criminal courts. Efficiency has long been a practical necessity, though a goal that has never been perfectly achieved. One of the first researchers to address this issue of efficiency in criminal matters is probably Professor Herbert Packer, who is the author that developed the idea that there are two models in criminal procedures. There's the due process model and the control crime model. Now, while the due process model is primarily concerned about the respect of fundamental rights and individual freedoms, the crime control model seeks primarily efficiency in the fight against crime, which implies both speed of procedure and certainty of conviction, which means reducing formalism and reducing the number of appeals. That's the whole point of an efficient system. Thus, and from that perspective, this model, it looks like an assembly line in a factory, which you have criminal cases passing by that looks like products with no particular procedural obstacles. The prosecution keeps prosecuting and cases go by and go by, like a factory, or like McDonald's preparing hamburgers, for example. It's a chain. And this crime control model is open to the idea of plea bargaining. Plea bargaining is simply the fact for a prosecutor to propose a sentence to the defendant, for him or she to accept it, then avoiding criminal procedure or simply going to trial. So it can take an hour, for example, in the US criminal system, or for example, a week for the defendant to choose whether going to trial takes weeks, months, and sometimes years, especially in criminal matters. This metaphor of the assembly line by Mr. Packer is not insignificant and refers explicitly to the concept of McDonaldization, which operates exactly the same way. When a customer in McDonald's orders a burger, for example, he knows what to expect, since all the burgers are all the same, and he will have them in a few seconds. However, what happens if he wants something else? For example, extra salad, extra ketchup, etc. It takes more time, because they have to specifically design this burger for that person. Well, it's the same thing in the criminal procedure. To some extent, if it's a plea bargaining, it's very quick. They're all the same. Even if the facts can change, they all have the same process of dealing things. However, if the defendant exercises right to a fair trial or simply to a trial, well, they have to adapt the case to him. Whereas in a normal plea bargaining process, there's not a question of adapting whatsoever. So the circumstances are quite similar. Furthermore, in terms of defendant rights, there are here two problems. The right to a fair trial, of course, because when you plea bargain, you don't go to trial. And there's the question of publicity. All that is behind doors. So, namely, those two rights are disregarded simply for efficiency. The second thing is cost effectiveness, but Mr. Ritzer talks about calculability. I've entitled that Time is Money. A very American way of thinking, but it is gaining also European countries. Cost effectiveness refers to the quantitative aspect of McDonaldization, meaning the cost and time it takes to produce the finished product. It allows, for for the institutions to produce and obtain large quantities of things very quickly. And this then determines efficiency. Now, in the United States, there's an indicator called the plea bargaining indicator, which namely means that out of 100 cases, how many cases went through plea bargaining? In other words, how many cases did not go to trial? Well, it might frighten you, but 99 out of those 100 cases do not go to trial. It is only plea bargaining. Now, we don't have the same things in European countries where they apply a plea bargaining, such as France, but also Eastern European countries, Italy, but it is not at the same level. However, this is not the plea bargaining indicator, but the idea of criminal response. In 100 cases, how many times did the prosecutor prosecute those cases? Now, in France, it's around 80%, so 20% did not receive a criminal response, so they are at rest, let's say. And from those 80%, there's 20% that is through the use of alternative ways of prosecuting, including plea bargaining. Now, this shows that those indicators are a weight for the justice system, because the idea is less to protect fundamental rights, but more the idea of fighting crime, and fighting crime whatever the cost. And of course, this influences those right to a fair trial, etc. Because the idea now is a question of numbers before a question of people. The second thing is predictability. The idea here is the question of sentencing guidelines. Predictability, in the way Mr. Ritzer thinks it, means that products and services will be uniform everywhere and all times. And he says there are no surprises. Well, there are no surprises too now in the criminal justice system in Europe and certainly in the United States. There's a principle that exists in some European countries, Eastern European countries, Italy, France, of individualized punishment. And there's also the idea from a broad interpretation of Article 7 of the European Convention. And the idea is that the sentence must be individualized, meaning they must be adapted to the defendant's personality and to other aspects, the gravity of the facts, where it happened, the circumstances, etc. Lots of elements to be taken into account. However, in America, it does not exist, or it's tending to exist through criminal matters involving death penalty. But otherwise, it does not really exist. And to make sure that things go faster, they built up what we call sentencing guidelines, meaning you have a chart with the types of felony and the criminal record of the defendant. So 2 factors. What did he do? And has he done that in the past? So it's only 2 elements. Whether in France, we take really the kind of personality, social background, etc. And there it's only 2 elements. And those 2 factors have come into Europe, and French jurisdictions are using those sentencing guidelines to go, again, faster. But where's then the question of individualized punishment? Now, of course, it's here to assist judges, assist prosecutors. But where's the limit? Especially when you have to go fast, time passes by, and you still have this criminal response indicator that is in your head that you must not forget. Finally, the idea of control. And here, George Ritzer says that the dimension of control is attained, especially through the substitution of non-human for human technology. This tendency, which is not unique to McDonald's, enables the company to far better control for uniformity of production and at least partly eliminate the hassles of having to do with human beings. Human beings make errors, whereas technology tend to make less errors, let's say. That raises the question of predictive justice. predictive justice, that can be kind of science fiction for some, is a reality. In America, they've used programs like Compass, which decides whether a suspect should be incarcerated before trial or not, if there's the likelihood of recidivism, which may also alter a sentence. In countries like Estonia, for example, they've used this kind also of program for some felonies up to 7,000 euros. But again, in this kind of predictive justice, more and more judges and prosecutors will be using this kind of software that is primarily there to assist them. But the question of time is money resurfaces, and therefore will take into account this kind of technology that apparently is without any mistakes. But this tends to deshumanize the criminal justice system by using that kind of technology, and therefore the human rights that are behind. And sentences also will look all the same, but also the question of individualized punishment for European countries for which America is not attached at all or very little will also be harmed in this way. So in one sentence, the motto from McDonald's is, "I'm loving it." Well, if we even maybe can discuss if we love their food or not, I am not sure we can love this way of functioning for the criminal justice system in the light of the human rights that can be harmed in the criminal justice process. Thank you.
Thank you. So the titles and the topics are really interesting, about McDonald's burgers, about wine, about rinsing liquid. So we have different topics, different titles. And the last speaker of this session, of this first day of a conference, is Olga Afonina. She is, I understand, from Ukraine right now. Are you in Ukraine right now?
Yes, I am.
Yeah, she is from Karazin Kharkiv National University, and her topic is the main directions of e-democracy development in Ukraine. So yes, the floor is yours.
My greetings to everyone. Maybe I will share with you my presentation. Everything is ok? Thank you. Sorry, something I can't say. I will share with you like this. First of all, dear participants, it's a great honor for me to take part in this conference. Now I am in Ukraine, yes, in Kyiv, and due to the Russian invasion in my country, all Ukrainians are protecting our independence. And it's so important for us to have a huge international support, especially that you support me to take part in this conference and to share with you our Ukrainian experience, especially in the field of electronic democracy. I am a PhD student at Karazin Kharkiv National University, and my PhD thesis refers to the topic of political rights and electronic democracy, especially. And today I would like to share with you some Ukrainian experience which refer to the development of electronic democracy. So let's begin. Let's me explain you based on the next slide. It's about overview of my presentation, which refer to the next issues. First of all, it will be an introduction about electronic democracy, and after this, we will speak about different directions which may help to improve electronic democracy. First of all, let's start from the definition of the electronic democracy. Firstly, you may say general definition as electronic democracy, also known as digital democracy or internet democracy. I would like to mention that it's so important to understand that always electronic democracy we understand as a connection of political and governance processes. And always we have this link between constitutional right to take part in some different state issues. And of course, this electronic governance, especially its story about citizen and the state. So secondly, I would like to share with you these different examples with citizen political activity, which citizen may use these different tools which citizen may use as part of electronic democracy. And I have to say that it's really a variety of activities. It's quite a multidisciplinary tools, and this list is not exhausted. We always have to understand that in our informational era, we have this development of the different informational technology tools, and it's not. It's always about new and new tools which help to discover how electronic democracy may be important for our states. And as about examples, you can see that it may be online consulting, electronic participation. Of course, it's about online surveys, electronic voting, budget participations, etc. It's about general understanding and general definition about my topic. And the next slide, I will share with you our Ukrainian experience in this way, especially the main governance body which supports the development of the electronic democracy in Ukraine is the Ministry of Digital Transformation. It was established in 2019, and this governmental body support a lot of different electronic democracy initiatives, especially, of course, it concerns the draft. This Ministry of Digital Transformation has a lot of different projects, and one of them is DIA, its application. In Ukrainian, the name is DIA. In English, it may translate it as State and Me. And this service, from my point of view, one of the best example how Ukraine has this way to develop our electronic democracy. And it's so proud to be the first country in the world where electronic passport obtained the legal force equally with the paper passport, especially in Ukraine. In our application DIA, we may show our passport, and this document always have the same legal force as, for example, our paper passport or ID passport. Of course, DIA has a lot of application, other electronic documents. For example, due to the war in Ukraine, a lot of people may lost their documents, and we have kind of little documents in our DIA with which help to clarify your identity. It's kind of electronic document, general document. This document also help our citizens to have some different services in Ukraine due to this difficult period of time, and help to obtain some services. Of course, among different electronic documents of Ukrainian citizens and other diversity of electronic services, we have, of course, online surveys. This one of the vivid example of electronic tools as part of electronic democracy, which help our citizens to take part in the some issues with regard to the state. And for instance, all Ukrainians had opportunity to vote for the war mark, for the postcard and letters, for Ukrposhta. Ukrposhta is one of the biggest post office in Ukraine, and it was an open voting in this application. The winner was the mark with the phrase "Good evening, we are from Ukraine." Into Ukraine, it means "Доброго вечора, ми з України." I think some of them may hear this. This one of the example when all Ukrainians take part in some issue, especially choosing the mark, which may help to remember the world about Ukraine, about war in our country, and this mark always is part of our informational work to support Ukrainian people. And I think that it's one of the huge work of the Ministry of Digital Transformation, which always trying to find different way how to ask Ukrainian citizens about different important issues, and of course, according to the opinion of Ukrainians, they always feel in this connection with the Ukrainian state, and they feel this connection that they realize their constitutional rights. But at the same time, Ukraine is just on the beginning of our development, especially in electronic democracy, and we have a lot of challenges. Of course, the main challenge for us is to win in the war with Russia, but other issues is so important, and I would like to discover some of the three directions of the development for electronic democracy in Ukraine. Especially it's concern political issues, legal issues, and technical issues. Firstly, I would like to share with you first point. It's challenges which refer to the political issue, especially it's about political manipulation. I find this way is so important because we have to understand a lot of different information communications tools which state may use for asking people for some important issues, or for instance, it's concerned also electronic voting. And this way, it's a huge responsibility for citizens to be aware of their rights and information. And when we have some problem with misinterpretation of information, this situation may be a result of misuse of digital tools. And firstly, when we are talking about this direction for electronic democracy, we have to remember about appropriate political education, appropriate digital skills for citizens, and of course, it's a big challenge for the state to support all of this educational system. And of course, this issue linked with the other direction of development, which refer to the legal issues. This is the second direction, which I would like to discover with you, because I, of course, as a lawyer, always remember about different diversity of the legislation, which may help us to build this Ukrainian legislation in appropriate form. Starting point, this legislation has to be consistent of the diversity of the relevant laws. And the key point, which I would like to share with you, it's adoption of law on electronic democracy. Electronic democracy requires a new approaches and standards. We have understand that, for instance, when we're talking about electronic votes, this concern new principles, new standards, and it's not at the same when we're talking about usual democracy. And one of the examples of these new approaches refer to the personal email address for every citizen, because unfortunately now Ukraine have some drafts, but we haven't this law. And let me go further, and I would like to tell you about the third direction of development. This refers technical issue of electronic democracy, and I would like to tell you about 2 points. First of all, it's about data protection. Secondly, it's about technical appropriate information technology equipment. Why it's so important? Firstly, it's so important to clarify irrelevant data protection tools. They may privacy protection may provide citizens with the confidence in their participation. They have to be sure that every information, every data which state may collect from them have to be with the appropriate protection according to the last standards and technology issues. Because data protection has become a new digital demand for implementation of electronic democracy, and state, of course, responsible for this. And in the conclusion, I would like to share with you this general idea that informational era, of course, it's a huge opportunity for us. And Ukrainian, I'm really happy that Ukrainian has begun this way to develop our state in the way of providing citizens with a lot of ICT tools for us. And of course, I believe that it's so important for us to develop these 3 issues, especially legal issues, which refer to the legal framework, political issues, because misinterpretation of information and political manipulation, it's always become so dangerous point for development of the democracy. And last one, of course, it's about technical issue. For instance, one of the good example among them is data protection. And I can say that this general conception may help to develop electronic democracy not only in Ukraine, but of course, I think it will be suitable for every country for which as Ukrainian on this way to develop with the information technology. Thank you for your attention. Maybe you will have some question. I'm really happy to share with you my ideas.
Thank you for your speech. Thank you for every speaker. Now we have time for discussions. So, yeah, I see we have already questions. I'm glad. So, yeah, please, Carolina. If you want. We need.
Dear Mikhail, I'm looking at you. Thank you for your speech. I'm quite impressed how it's easy to follow even without the slides themselves. What I have written down is that it's quite an interesting approach that you suggest, but I'm anti like supranational and some centralized rulings. So I'm just wondering, have you considered what could be the drawbacks of having such a centralized body to regulate AI decisions and so on?
You mean some...
Pardon? Olga, right? Yeah, that's a question for a previous speaker.
Oh, Vaso, I'm sorry.
No, no.
Thank you. As I understood you correctly, you mean the background of such organization, the conditions on how it works? Or
No, what problems could it cause?
Of having like a supranational organization. The problems are quite obvious for me. How could we force states to respect such organization? As we know, law, and international law in particular, is based upon the state's consent. How can we receive such a consent? If we have one, I can see a lot of benefits of having such a transnational global organization, which consists of bodies responsible for setting rules, something like a court, I mean a judicial body, something like a prosecutor's office. I can see a lot of benefits, but the biggest problem for me now, the real problem, is how could we convince states across all the world to give the consent for establishing such an organization. We are unable to do so with very important issues such as human rights, because we don't have a central body for human rights, which is transnational. And of course I know, and I am aware of the problem that AI can lead us to some human rights issues, and that's obvious for me. However, I am not sure if we are now on the position, I mean, whether we are in a good phase that that states agree that AI can lead to problems that are as serious our human rights problem. Maybe some would like to.
Perhaps it's even more neutral, as human rights causes a lot of issues.
Human rights are human rights, and AI is AI. And personally, I often cannot. I personally see some links between human rights and technology. However, some people, some governments especially, they do not. And this is the problem. If they do not see links between human rights, for example, and AI, of course they will not give a consent for establishing a centralized body.
Yeah, thanks. That's exactly the point I was making, that you need to inform and educate the people first. Exactly. A brief question to Pierre.
So Pierre has actually a lot of questions, and I see on internet he has a lot of questions. Yes, I see also from the public question. Micro. So perhaps I will get the microphone.
Thank you. I thought I might just add, because it's a question that goes to as well Daria, but also Olha, whoever of you wants to answer, because it is related to e-democracy, but also I think to AI, because you mentioned that countries should be deemed either AI ready or not. And I was wondering what you thought would be a criterion to determine whether they are or not, because with e-democracy, I thought about, would it be necessary in order for everybody to participate in an e-democracy equally? Do we need a right to the access of internet, to the access to hardware? And would it be an appropriate factor to deem a country AI ready, because that might be the next step in e-democracy, to take on this challenge in AI? Would this be a factor to determine whether a country is, well, AI ready, as you said before? Do we need a right to internet? Does this mean a right only to internet access, or as well as to hardware and software?
So perhaps, first of all, we need answers from Daria. I understood from Daria, or from Olga, or from Mikhail. Yes? Yeah. So who would like to answer? I think it's a question for you about AI.
Okay. What I really think that it really depends. It really depends if we talk about our part of the world. I mean, for example, Europe or the US or Canada. America, or whether we talk about global south, because the situation is really different. In our developed countries, I think that the right to internet, especially in the present times when the internet is closely linked to some other human rights, for example, the right to the freedom of speech, it is often closely linked to the right to the access to internet, the prohibition of fake news, which of course, maybe I am moving too fast, but there are some links between the prohibition of fake news and human rights, and it's present in modern world. I think that there should be a right to the internet, but the problem is, what does it mean? Access, which means Wi-Fi or some phone services, or what does it really mean? The problem with hardware. Who should be responsible for hardware, for computers, maybe for mobile phones, for tablets? I am not sure. I know that in developed countries, the problem with hardware is maybe not so serious, because developed countries are maybe not rich, but they have some funds. So maybe if we set some criteria when the state should be responsible for providing hardware, it may work. But it may work in our part of the world. What about the Africa? What about Latin America? So I'm not sure if the right to internet should be a human right that is applicable globally. The idea is very good. There should be. However, we should think about the reality. Because if we do not treat law as a part of reality, as a reflection of reality, it means nothing. Because the law, to be effective, we have to have the possibility to execute the law. How will we execute the law in the global south? It is impossible. So the problem, in my opinion, is really complex. But in general, I'm in favor of the right to internet, at least in our region, European region, for example. Yeah, it is. It is. Yeah, maybe you want to add something. No.
Okay, so thank you. And I saw in the public you had a question.
Yes, Carolina. Thank you.
Try to be gentle.
I was interested about your presentation, and it's from where the question derives from, not from my any vicious intentions, let's say. But indeed you spoke, yeah, indeed you spoke a bit fast. Therefore, if I'm going to ask about things that you have already said, I beg your pardon for it. But I'm really curious. So when it comes to this conflict of who should decide, right, about the scope of the legitimate use of a product, isn't it more a matter of a broader competition policy? This is my question, and let me a bit expand on it. So. In my opinion, it is the competition law which gives the basic image of the market and the outcomes that the market mechanism should lead to. And the conflict that you have depicted touches upon the question whether for what kind of competition we allow. So if we allow for the market participants to compete on, in a toxic way, on things like taxes, for example, on consumer security, basically on many values that are protected by various kinds of EU consumer law or fields of consumer law. So maybe forming this question to a clear direction. Do you see a potential to solve this conflict of drawing line where the consumer has to be given the broadest possible span of to decide how to use a product, and the scope of the producer's legitimate ability to restrict the use of the product by forming a competition policy in a certain way to make it to like involve in it also values like consumer protection, for example, sustainability, things like that, and resolve this conflict in this way. So thank you.
I look forward to answering this question. Thank you so much. Let's say a fora that I was not able to comment on today was that there are particular private party rights of different alcohol producers, of brand alcohol producers, and with this policy being applied, their, how to say, their like what's it called? Fundamental law to fair competition. Sorry, fundamental law to endure fair competition is completely infringed, and this has to do a lot with how these brand producers. Private ownership rights are restricted in that sense. I agree upon the market mechanisms, and the problem that I find is that the European Commission only applies the market mechanisms when it has to deal with only 2 articles of the TFEU that have specifically about entering a market for a new player. Nothing to do with the consumers. They do not like extrapolate its usage in different spheres. And this is one of my recommendations as well, is that the market-based approach should be applied in all matters considering product classification, competition of products, and so on. And that's actually what the World Trade Organization does, because when it's deciding among the competition things, it looks into how the consumer treats it in order to ensure the fairness of the competition. Private laws, yeah, I think, did I respond to it? Is it clear?
If you, for example, restrict the way a product is distributed out of, for example, consumer safety reasons, for example, it can be distributed only in pharmacies, out of consumer care.
I disagree with that, of course.
Yeah, but it may provide a reasonable justification for the sake of consumer protection. If this product is to be harmful, for example, to consumers, and you need a professional advice, and like involving those sustainability, consumer protection aspects help to like provide clearer guidelines how to resolve this conflict. Let's say, but
so thank you. I think you can discuss it in the evening or during
Definitely
excursion.
Continue on this, yeah.
Yeah. So as we do not have much time, as excursion is waiting for our guests, so I have a few questions to prepare from online questions. So first question is: do you believe that McDonaldization of criminal procedure shows the declining difference between common law and civil law systems in criminal procedure? And the second is quite also similar. So what do you think about jury institute in criminal trials in continental Europe? Is it also like McDonaldization of criminal justice or not?
Okay, thank you for the questions. First one, totally. I think that the McDonaldization is a sign of the way that civil law countries are looking like more and more to common law countries. And the fact that predictive justice that I couldn't develop because of time issues is that this software is based on jurisprudence, and the cases deal only, well, the software deals only with the facts. So the judge, for example, puts the facts in the computer, and the software says, well, out of all the cases that have been concluded dealing with this matter, the answer is this, or this sentence is this. That looks a lot like common law, because common law is based on case law, on cases, and does not take into account the rule of law, but the rulings that have been made, which is a huge difference. And this also still on the fact that civil law is becoming a kind of common law. It's not very surprising because especially in France, for example, the American cultural heritage is huge. In terms of films, for example, in terms of literature, thrillers, for example, in terms of food. I mean, fast foods, there are fast foods at every street. And all those elements and art, etc., and the language also, all that is it's cultural heritage, or it's cultural, but also the law and the way we think and judicial culture, let's say, our legal culture, is also then logically influenced by this. So we're still a civil law countries, there are differences, I mean, the conditions for plea bargaining are not the same, truly, but we're surely but slowly going towards that. Now, the second question, I'm sorry, my
about
memory...
jury in continental Europe?
Grand jury, yeah, same. Grand jury, for example, in criminal trials exists also in civil law countries. But, for example, in France, I don't know for other systems, but they tend to get rid of the jury, especially in special matters such as rape, for example, because there's a huge stock of cases involving rape. And so they're trying to, sorry for the language, but get rid of the jury in order to go faster. Now, in America, the grand jury exists both in civil and criminal matter at all stages, for felonies and crimes included. And it's still there. But the difference is that even though we're leaving a jury away, it's still in that spirit of marginalization, going faster, and for a question of money. And I just want to finish without the question of time is money, is having a jury system, it costs a lot, obviously. And so not having a jury is making some money then. And instead of budgetizing all this, instead of implementing more money in it, they resolve the question of time by making mechanism that saves money and also allows you to go faster. So the question is today is not we have to put more money, is how we can make things faster by not spending any money. And I think it's a way, of course, that is quite smart, but of course at risk. There are some human rights involved, and especially for the rights of a defendant to have a jury.
Thank you. Well, can you ask it in the evening?
Yeah.
Yes,
So
thank you very much for all the presenters, speakers online from Ukraine and from Europe, and all of you. And see you tomorrow. I mean, in the morning at 10 a.m. And we will have third and fourth sessions of our conference. So thank you, everyone.
Yeah, and now regarding our today's activities, so don't forget that at 4 p.m. all the participants are having excursion in Vilnius University, Universiteto Street Free. All the information will be provided, was provided to you by an email, but will be provided in a couple of minutes in email too. But don't forget, and 7:30 p.m. we have a dinner at the Grey Restaurant, is it Pilia Street 2? Yeah. So, and thank you very much for the discussions. We will be able to have discussions in Grey and during the discussion. Thank you very much, and see you in an hour.